has been issued on dated 8/5/2015 and it has not been executed. Last occasion, this Honorable Court has directed to take instruction.
Yes. Production of the accused person, but imbue has not been executed.
But I start one page my note, my lord.
What?
IO, my lord.
Yesterday
I contacted IO, my lord. He stated that the accused persons, my lord, as absconder, my lord. During verification of PS record, register, it was found that both the warranties belong to Kolkata. Postman who comes under PS such and such PS, my lord. Then the IS returned, then IS, who was the IS in 2019, my lord, he returned the warranty to the Court of Honor SGM also showing the as a wrong address. Now such warranty are not available in PS.
Address is not there.
My lord. Wrong address given to the PS, for that reason the warranty returned to the Court of Honor.
So what is the what next?
They belongs to, my lord, the next process, my lord. The court has to, when they have given the IO given the correct address, my lord, the court has to send the warranty to the correct address, in the correct address to Kolkata for production.
Which court? That
My lord, the
court of SDJM.
My lord.
Culture.
But the warranty issued against the petition, those are belongs to, my lord, Kolkata, my lord. And the charge sheet submitted against them, showing them absconder. And their charge sheet, the address also shown in the charge sheet, my lord. The court should have, my lord, sent the warrant to the concerned PS for their production.
By way of this petition, the petitioner seeks a direction to the Superintendent of Police
and the IAC.
And the IAC production of accused person, that is opposite party number 2, for execution of the warrant issued against opposite party number 4 and 5.
Yes, sir.
Opposite number 4 and 5.
Yes, sir.
The coordinate bench of this court on 1/5/2023 directed the IIC Talcher for production of the accused and after executing the NBW. Pursuant to the said order, the IIC Talcher has submitted a report inter alia stating that the addresses of the opposite party number 4 and 5 are wrong. That is the reason it could not be executed. Therefore, Mr. Ragada submits that press address needs to be furnished. Press address of
their address is correct, in charge their address at Calcutta, my lord. Instead of issuing notice to issuing warrant to the non-STM to the local, sending the warrant to the local PS, just send the warrant to the IS Talcher. For that reason, my lord, since in the charge sheet, my lord,
Mr. Ragada submits that the fresh warrant needs to be issued against the opposite party number 4 and 5.
Their address
in the address given in the charge sheet. So accordingly, it is directed that the court of directed.
It's not pursue, my lord, the court below.
No. Who is the Lord court below? It is directed. SDGM, which SDGM? Talcher may do good to issue fresh warrant against the opposite party number 4 and 5 in the address given in the charge. Matter is accordingly dispute.
And also, my lord, your lordship also directly petitioner also who the informant. He also, my lord, pursuing the case for
petitioner may also pursue the matter before the learned court. Take it up.
Obliged.
Item 2,
May I please, Lordship, on behalf of Mr. Mahanti, Lordship. Last occasion, it's a amicable settlement. And last occasion, it's a for injury.
Speak little louder. In the morning, you don't have energy.
Last occasion for injury.
What do you want?
Amicable
Quashing, my
settlement
lord.
questioning.
They both parties.
Both parties are
That's what.
My lord.
For injury, my lord, for verification injury report, that has been answered.
simple.
Injury report?
Simple.
It's simple English.
Simple English. Okay. Who all are they?
My lord. Parties are present.
Sanjay Vishwal, Arif Khan, Nawab Sharif, Manasi Naik, you are also there. Dadu,
Company
No.
is-
Rehman,
Yes, sir.
settlement ହେଇଯାଇଛି କଣ settlement ହେଲା ବିବରଣୀ ହେଇଛି affidavit file କରିଛ
My lord.
Well,
the petitioners are facing what is the stage of the trial
My lord.
Investigation.
in
huh
My lord, the case has been
Final report
committed.
submitted, my lord. Charge
Sorry?
submitted.
the petitioners the FIR number so and so Lalbagh PS so and so was registered against the petitioners under section so and so at the instance of the opposite party
My lord,
number
one thing,
two.
my lord, matter has already
Matter
been
is-
committed, pending in the Sussex court.
session.
After investigation, the charge sheet was laid down by the police, and subsequently the matter has been committed to the court of sessions. The petitioners and the opposite parties have entered into a out of court settlement by the intervention of village gentries. Therefore, the petitioner seeks to quash the entire proceeding. The opposite party, number two, being the informant and as well as the victim. Informant and
Yes, my
injured.
lord.
Injured.
Yes, yes.
Opposite party number two, being the informant and the
Actually.
injured in this case, has filed an affidavit, which is affidavit entirely stating that he doesn't want to proceed with this case against the petitioners. Mr. Ragada, IPS for the state, submits that though the petitioners are taking the trial under section 307 IPC, but the medical record placed on record indicate that the injuries are simple. Injuries are simple. Therefore, in view of the fact that the parties have now settled the dispute, there is no legal impediment for quashing the FIR. The petitioners and the opposite party number two are present in the court. They are represented by their respective counsels, and they are identified by them. They have also filed their self-registered copy of their Aadhaar cards to establish their identity. Next up, having taken into consideration the facts and circumstances of the present case and the statement made at the bar, and taking into consideration the medical report placed before the court today, take it on record. Take it on record. Place in record today. I am of the considered view that the present FIR and the consequential proceeding arising thereof against the petitioners are liable to be quashed. Accordingly, how much cost? How many of you are there? All of you have to pay 1,000 each. You have beaten.
My lord, may I pray for 500 each? If your lordship pleases, I cannot bargain, my lord, but
See, what have you done? You have beaten someone,
my lord, that was
and you will
because of
keep some deterrent has to be there.
my lord, that I cannot come in the way, my lord. If your lordship
some
directs
deterrent
something,
has to
but
be
my
there.
lord, that amount because collectively one has to pay, my lord.
How many cases are there against these people?
No, my lord. Only this is the CRLMC which.
And how many cases? Arey,
आगुर केते गति
Oh,
ए केतला
ତମ against our case ଅଛି, pending ଅଛି.
अपना आपन पेशो अछि ନାଇଁ ଗୋଟେ କେସ୍ ସତ କଥା କହୁଛ
ସତ କଥା କହୁଛ ନା ଏନକ୍ୱାରି କରେଇବି?
ନା ଲାଲବାବୁ କହିଲେ ଇନକ୍ୱାରି କରି ଆସନ୍ତୁ ଆଉ କାହିଁ ସ୍କାନର ଅଛି କି ଆଗରୁ ଗୋଟେ ସ୍କାନର
Accordingly, the FIR number so and so, and the consequential proceeding arising therefore or cause, subject to the petitioners. Okay, how many of you are there? Five. Subject to the petitioners paying 1,000 D cost to
The High
be
Court
deposited to
welfare.
High Court welfare. If 1,000 D. Public.
item 3.
My lord, on behalf of Mr. Samuel, I pray for next week.
Adjourn.
Item 4.
Yes. Password.
Item 5.
Yes.
Maybe.
Yes.
Here I have challenged the FIR and for the proceeding of the case, where in a case under section 304A, 506, of the SCS Act has been registered. The fact remains as per the FIR. Can you have a glance to the FIR that starts from page 8?
We are seeking staying up investigation.
No, not exactly investigation.
That's
but
your prayer. Just see. Admit the case, issue notice to opposite party after hearing the parties, the investigation and further proceeding. So and so.
I have said so, no coercive.
You want the investigation?
It's a case where I see the main petitioner are the headmaster. One is the headmaster and other teachers of the school. And they are, as per the usual routine work, they were acting in the particular school. At a relevant time, they found a small boy was somehow tried to enter inside the particular school, which body was having his seat. So the petitioner has said that go and clean the your body.
Yes.
That's all only.
What is
He went.
304 capital?
I am coming. That particular boy went to the nearby pond, but he has not returned. That is not, my lord. I have not no knowledge about all such things. After some time, he was found, my lord, dead because of drowning. Now the case has been turned off by the villagers or the persons that because of your insistence, he had been to the particular pond, and because of you only, he has died.
Yes, Mr. Raghunath.
My lord, what is the investigation?
What is the investigation?
What is it? My lord, the FIR, my lord, only registered, my lord. Investigation going on. Only, my lord, month of 8, my lord, August. August. My lord, I'll take it my first time, my lord. Come, I'll take it.
That's right, but the allegations are such. They are the school.
Madam.
He comes with
Madam.
dirty,
Madam.
completely dirty.
That is true, my
And
lord.
these people say that go and take bath and all.
Madam.
He goes and
My lord, the-
somehow drowned.
My lord.
So then
Case diary 161 and submitted, my lord.
304, I think.
My lord.
They are teachers after all.
That is true, my lord. But in fact, my investigation will say, my lord.
That's right. You.
Lord,
So I'm just issuing notice.
Please-
Check it up and tell me. Check it up and tell me.
Madam.
At least 304 should go because they are teachers that try to
Madam.
understand. Some misunderstanding may be there, but
Madam.
not.
Go and clean your
कोई भी जा कोई लड़ से जाएगी पोखर
One particular thing has happened.
Very unfortunate, but what?
Madam.
I'm just issuing notices.
Madam.
Take it up. Huh? Yes. Returnable within 1 week.
My lord.
Don't delay it.
Madam.
If it is very, see, these are the teachers. If these kind of cases are there in their head, what they will perform in the school.
Madam.
So better that you finish it up. Investigation. And,
My lord.
shall I write that you will complete the investigation?
No, my lord, I will call for the criteria. I will ask.
Next week, the top you write. Next week.
15.
15th, okay. Put it in 15th. 15th.
19 तारीख 19 तारीख
But make sure that investigation is complete. Okay. Yes.
Item 6.
My lord, item OP2, my lord.
OPT, not notice. Yes.
My lord, item 6 password.
Huh?
Password.
Okay.
Item 7.
Item 7 permitted to withdraw, my lord.
Very good prayer. Withdraw.
Item 8.
Password.
Item 9.
Password.
Item 10.
Yes.
Item 10 1 failed marriage, my lord. I will take instruction with the status of the case, my lord. Lordship taken up.
Counsel for the petitioner seeks an adjournment to obtain instruction from his clients regarding the present status of the adjourned. Yes.
Item 11.
Nobody likes to come to this court before lunch. Yes. 12.
Item 12.
Yes. 13.
13 already.
Done?
It's mentioned earlier.
Okay.
14.
14.
Item 14 pass over, my
14.
lord. 14.
You
I'm sorry,
have passed over.
I'm just seeking an adjournment.
11.
I'm for the petitioner.
Is it a afternoon matter?
No.
Fresh
It's a
matter?
Fresh matter, fresh matter.
Fresh matter again. Mr. Raj takes time.
Fresh matter.
14 pass over, my lord.
11.
Pass over 14, okay.
Hon'Ble.
15.
15.
Please, your lordship, my lord. In this case also, NBW has been issued on 11/5/2022, my lord. Yet not executed. Yes.
I'm sorry, I'm not able to follow you.
My lord, in this case, NBW has been issued on 11/5/2022
Okay.
by the Learned JMFC Kujanga.
You were on bail?
I am for the informant, my lord.
Informant.
Yes, your lordship.
What do you want?
Execution of NBW, your lordship.
It will be done when the NBW was issued.
On 11/5/2022, your lordship.
You are seeking direction against whom?
Against opposite party number 3.
I see. The petitioner is the informant in this present case. And she submits that though the NBW was issued against the accused person on
11/5/2022.
11/5/2022, but it has not yet been executed by
Yes.
the opposite party number 2. Opposite party number 2.
Yes,
So
sir.
therefore, he seeks direction. Direction. The next Mr. Maharaj appeals for the state, waives notice, and submits that the opposite party number 2, being the IIC Kujang police station, is duty bound to execute the NBW issued against the accused person. So therefore, the petition could be disposed of at this stage with a direction to the opposite party number 2 to execute the NBW issued against the petitioner by the court of
Learned JMFC Kujanga.
JMC Kujanga within 1 month, 15 days. What is
15 days?
15 days from today. Matter disposed.
Obliged, your lordship.
16.
Item 16, your lordship, the petitioner challenges the order dated 5/10/2023 passed by the Learned JMFC, your lordship.
Yes.
The petitioner is the informant. The petitioner is alleged in the affair that she was staying in her in-laws house. Now, after the death of her husband, there was dispute. So she was compelled to leave the in-laws house. But all her belongings that were kept in one room locked in that original house.
Okay.
It was there. Thereafter, many things happened. They discussed for settlement and matter. Now, one day, her sister-in-laws, who are the accused persons in this case, they threatened that unless you take away all the things from that room, we'll throw it away. She requested that let it be there, I'll do some arrangement, but they didn't agree. They have broken open the lock, took away the valuable certificates, the originals of the petitioner's son, threw it away in front of the security room of the flat where the informant is presently residing. The things which have been thrown are still scattered there. As on today, even it is there. So the informant filed this, lost this FIR. Police conducted investigation, submitted charge sheet. Now my allegation is under section 454(380), your lordship, breaking upon this house and throwing away my articles, taking away my articles. That is the principal allegation.
You are the informant.
I am the informant.
Okay.
Now the police submitted charge sheet under 454(380), your lordship, without conducting any investigation. Now it is a very common thing, your lordship. If tomorrow I will be the witness.
Protest petition.
My lord,
What 482?
My lord, the reason, your lordship, I have filed a petition under 173(8) that it requires further investigation.
For that, the procedure is settled.
My lord, that
You
is
have to
that.
go to the probate court.
That
you
is
have to
that is
file
the that is
probate
exactly the judgment passed by this honorable court.
protest petition. Sorry,
No, my
probate
lord.
court.
With respect, my lord, 173(8), our own honorable High Court said when there is no investigation on a particular point, your lordship may very
These facts to facts different.
my lord,
You
but
can't
my
bring-
fact
there
is similar.
there is no thumb principle in this.
Thumb rule is not there. My
You
fact
are,
is very.
you are aggrieved by the fact that the police has filed a charge sheet without invoking a particular provision.
No, my
The
lord.
case is made out.
With respect, your lordship, that is not the submission.
Right.
Police has filed a charge sheet under 498, 454, 380, 427, 506 by 34.
Okay.
Now, 454, 380, your lordship may kindly see, and 427. 454 is housebreaking. 380 is theft in the dwelling house, and 427 is mischief with respect to movable property. Now, your lordship may kindly see the charge sheet I have entirely annexed. Annexure 5.
That's right. What exactly you want?
I want, your lordship, with respect to this breaking of the room and throwing of articles there, those which are very much available, those can be seized and given me to in Jima, because tomorrow if I'll come as a witness, I have to exhibit the seizure list and Jimanama. Unless I exhibit a seizure list, there is no case from my side. Those things are there, your lordship.
You say 173(8). Now you are
Yes.
saying Jimanama.
Yes, your lordship. 170.
482 court will decide Jimanama.
No, Jimanama is 482 court. I am not making a prayer to that effect. My prayer is with respect to the investigation what has been done. Your lordship may kindly see 173(8) petition I have.
Protest petition.
Your lordship may kindly see Annexure 6.
What is your prayer? Just see. You have
My lord.
made all the prayer under the sky.
No, my lord. With that I have limited my prayer that the order passed under 6/5/2023, if the order passed on 5/10/2023 may be set aside. Your lordship may kindly see, this is a very small judgment passed by our own honorable High Court.
Which order you want set?
5/10/2023, my lord. The learned magistrate has passed an order.
Annexure
7,
Okay. Let us read that.
my lord.
Now you, out of all the prayers which you have made, you are now confining to this prayer.
This prayer I have made also. I am
What is
confined.
you made so many prayers. That's the whole difficulty.
My lord,
What
I
exactly you are pressing.
exactly pressing Annexure 7 to be set
7
aside.
to be.
My lord.
Let us see 7.
My lord, Annexure 7, page 58.
Yes. Let us see.
Even the learned PP present in the court, learned FPP also submitted that it require further investigation. I am submitting, my lord. Annexure 7, page 58. Paragraph, I have heard on the petition, thereafter I am reading. Learned assistant PP, may I read, my lord? Learned assistant PP submitted that as per the mandate enshrined under section 173(8) of CRPC, the court has right to direct the IO for further investigation of the case. He has alleged that the IO has not properly investigated the case and hurriedly submitted charge sheet. He has submitted that the court may kindly be directed, my lord, there is some mistake. The court might direct the IO to verify the breaking of the lock of room in question existing on plot number 303, Bhomikal, Kotak Road, Bhubaneswar, and to prepare seizure list of the belonging of the petitioner which was stolen, and belongings thrown by the accused persons in front of her house, and also to verify and seize the CCTV footage of the said incident. He also drawn the attention of this court in respect of direction imparted by Honorable Court by the order dated 25/7/2023 that to keep the room in plot number 303 Bhomikal under vigil in respect of his contention. He has brought to the knowledge of the court the decision of the court in respect of Binubhai Haribhai Malavia versus State of Gujarat, reported in 2020, and the case of Honorable Court in case of Manoj Kumar Agrawal versus State of Odisha 2022, reported in Live Law Odisha 162. Concluding his argument, the learned assistant PP prayed to allow the petition and direct the IO for further investigation of the above for the aforesaid lacuna as committed by investigating agency. This is the submission by learned PP, my lord.
PP might have submitted at your instance, obviously.
Because I am the informant, I have filed the petition through the, my lord.
Obviously.
Through the FPP, I have to file it.
So therefore, it is your version.
My version through FPP.
Your version is highlighted by the PP because under 301 or something, you have to.
I have to get the
PP. Assist the PP.
Assist the PP.
Very good.
My lord.
What is the order then?
The order says, peruse the case record, it is found that the informant, namely Jyotirmoy Patra, lodged the FIR against her in-laws on 5/5/2023 After receipt of the written complaint, the IIC handed over the charges of investigation to SIR Oram. During course of investigation, the IO has visited the spot, recorded the statement of witnesses, acquainted with the case, made seizure of certain articles,
All the
documents.
thing you just skip over,
My
come
lord.
to the relevant part.
My lord, the on submission,
Essential ingredient of the investigation.
investigation of the IO, who is to keep in mind the following points.
On perusal of the record, this court feels that it is.
IO has investigated. Absolutely not, my lord. Your lordship may kindly see the seizure that has been made, which the learned court has referred at page 49.
It is not proper for you to further investigation. It is 174. What is this 156.3 CRPC?
156.3 CRPC, the power of the magistrate to direct proper investigation. When the police is investigating, we have
No,
filed,
you have moved an application 156.3 also.
read with 173.8. There is my application I have annexed, annexure 6. There must be proper investigation on this point, and it requires your lordship may kindly see the seizure list which has been referred by learned magistrate. Page 49.
Yeah,
It is
suppose you are resorted to 156.3, then you have to follow the procedure under 200 and 202.
156.3. I have filed a petition directing the IO for proper investigation, your lordship.
That's right. If the court doesn't agree, then instead of rejecting it, it has to be the procedure under 200 and 202 has to be followed.
That the complaint case I have not made.
156.3, what is this? 156.3 is obviously that is in the nature of a protest petition. You might not have designated that to be a protest petition, but you have filed a 156.3.
For proper investigation.
For proper investigation, no 156.3.
Yes, your lordship. I have filed that petition. I have
That's wrong. That's wrong. 173.8, it's all right.
My lord.
And
That
173.8 you have filed and 156.3 rejected. What is this?
No, 173.8 also. Your lordship may kindly say annexure 6. They have stated it 153.
Whether you have filed 156.3.
173.8, your lordship. They say they have.
Why then last paragraph what the court says?
The court says.
Where under section 156.3 CRPC is rejected. What is this?
Because your lordship, I have nomenclature in the petition. They have stated 153. I cannot dispute it. Annexure 6, the petition. Then that I admit, your
Then
lordship.
you have resorted to some
No,
procedure
the
which is
petition.
unknown to law. Then you have
The
to
petition
follow that.
heading says, your lordship, petition under 153 read with 173 clause 8 is the only they have stated, but 173 charge sheet submitted, my lord. Investigation is required, so it is 173.8. They have
Your application page 52 you see.
my lord. That is the heading they have stated. Petition under 153 read with 173.8.
So if you have resorted to 156, the procedure is different, sir.
I do admit.
So you follow that procedure.
This is in fact an
You have
application.
invited this. What can I do?
I do admit 173.8. I do admit this is filed in the Narayan lower court. Your lordship, I cannot improve upon it.
And your application under 156.3 is now rejected. Then you have to follow the procedure under 200.
This is, your lordship, an application under
You leave the
173.
evidence.
100. That is exactly the difficulty, your lordship. If tomorrow I lead evidence, my lord may kindly see the difficulty I am facing.
See the difficulty I am facing.
My lord, I bow down, your lordship. Page 49.
You have created so much of mess.
That is, your lordship, they have filed in the lower court. I cannot improve upon it. It is in fact 173.8 they have stated. And the fact remains that charge sheet has been submitted. Your lordship may kindly see page 49.
If the charge sheet is submitted, if you are not satisfied, the procedure is different.
That is, your lordship, it requires a further. I am not.
The impugn order is saying that the IO should have done this, should have done that. It's none of the.
My lord, there is no.
Is it discretion of the IO to investigate and file a charge sheet?
With respect, your lordship,
If you don't agree with that, then protest petition you file, improve upon this.
Your lordship may kindly
And for
permit
that,
me
for
to.
that you have already resorted to 156.3.
My lord may kindly
Okay.
permit me to place one judgment of our own Hon'Ble High Court. Again, only a very small judgment exactly on this line,
Yes.
my lord. With reference to Binubai Haribhai,
Binubai is relied upon.
Binubai relied upon, which says that after charge sheet is submitted, the magistrate is absolutely not powerless to direct further investigation.
Who is
My lord, in this case,
That's the law.
my lord, your lordship may kindly permit me to place one thing. My allegation is that the room where I
When you are
have,
going to the fact.
because your lordship, the seizure what has been made, it doesn't.
So I know that it is not properly done.
My lord.
You are not satisfied in everything. But what is the procedure for that? I
I
am just asking. 482 court will start investigating or what?
This is.
What is the procedure? You
this-
have resorted to 156(3), which is rejected.
My lord,
You
156.
lead under 200, 202, lead the.
My lord,
evidence and file a protest
156.3,
petition.
156.3 only nomenclature they have stated.
You file a protest petition.
Protest, I cannot make anything, your lordship. If your lordship may kindly
That's
consider.
the procedure, sir. What?
But I cannot establish any case because the seizure is required to be made by the police. In protest, I will not be able to bring anything.
You can summon them.
Your lordship may
Witness.
kindly see
You
page
can
14.
summon them as a witness.
My lord may kindly permit me to place page 49.
Yes.
What is my allegation? What the IO has seized?
I understand it. I read it.
The IO has seized marriage certificate, death certificate of my husband. This is not my allegation. My allegation is that in one room which I have kept locked, it was broken and things were thrown.
What is the any divorce petition, anything is filed? No.
Against husband is dead, your lordship.
Already.
My lord.
Is there any chance of settlement?
So it a settlement by what direction?
Direction thila. That is the order.
Settlement, you settle it to.
My lord, I don't dispute. I have even tried. I have no dispute with my in-laws. Your lordship may kindly see the order passed by this honorable court.
Then you have dispute with whom? IO?
My lord.
Investigating officer?
My lord.
With whom you have dispute then?
I have no dispute with respect to any property, anything, my lord. Let them enjoy their property. I have nothing to say.
Then what?
But this is an overt act, my lord. My son's original certificates were kept there.
It is lying there.
Half of the things lying there, half of the things stolen in front of my flat, which are still scattered today, even on today. If the IO will visit this place.
Mr. Maharaj, leaving apart the technicality.
Yes.
Why can't it be settled? Why
That-
can't you
that-
tell
that
the
is
IO
what-
why
that is what-
the IO is leaving?
Your lordship may kindly
Technicality
see.
he has a problem,
Yes.
My lord.
but leaving that apart, can it be sorted out?
Your lordship may kindly turn to page 25.
25.
That is what your lordship wanted
Okay,
to.
25.
My lord.
Okay.
Page 25, last paragraph.
Yes.
Paragraph 3.
Petitioners are directed to take all endeavor to ensure that the matter gets settled amicable, as is also advised to the learned counsel for the informant. It is also advised that the learned counsel for the petitioner to impress upon the petitioner to ensure that the room which was under lock and key of the informant to be restored to her.
They are the petitioners, your lordship, in my case before anticipatory bail in this honorable court. They are in honorable court has been pleased to say.
Then I'll simply issue notice, let us see.
Yes, your
If
lordship.
they can come, huh? We'll see notice. Oh, issue notice, huh? To opposite party number. Opposite party,
4, 5 and 6.
4, 5,
And 6.
opposite parties, huh? By the way, what are the relationship? The
Sister-in-law, your lordship.
sister-in-law,
My lord.
Jyotirmoyi Patra. Husband died.
Husband.
Husband died.
My lord. And she has got a minor son
He's staying separately.
along with me. I'm
No,
staying.
no, you are staying separately.
My lord.
You are working lady.
No, my lord.
Okay.
You have not filed anything for maintenance, domestic violence, or anything.
No, I am not. I have one 498 case I have filed earlier. So that as per the settlement done, that I am not pursuing.
You can pursue DB Act also. Why are you after this case? You can file DB Act and
With respect, your lordship.
Section 31 and all, you can do it.
My lord.
Anyway, we'll issue notice, let us see. Let them come. Yes,
Your Lordship, I am appearing for the sub-item 2, Your Lordship.
sub-item 2.
My lord, may I pray that your lordship may stay the further investigation, further proceeding, your lordship. I have filed because the learned lower court is.
How are you? You are informant, why should you
My lord,
stop it?
the learned
No.
the learned lower court is lordship
No.
is proceeding for framing of charge.
Let it be, if further evidence come, charge can be reframed. Why are you stalling?
May-
Please read it.
Huh?
It's not advisable.
Because your lordship, why I am making a prayer, my lord. Your lordship may consider. Once the court proceeds further.
No, first your lordship may kindly turn to sub-item, my lord.
So yes,
Sub-item,
Your
your
Lordship,
lordship.
in the sub-item 2, Your Lordship, I am challenging the very FIR that my learned senior is talking about, Your Lordship. I am representing the sisters-in-law.
you are
Some not.
in sub-item. What is the
Sub-item 2,
issue?
It's a CRLMC 282303.
That's right, but
this is for the quashing of the FIR itself, Your Lordship. I had filed the CLMC first.
for the accused person.
Yes, Your Lordship.
So
No,
you
this
accept
is-
notice. You accept notice in the first item. And there is a interim direction also in this matter.
Yes, Your Lordship.
That in the meantime, if the petition for adjournment is moved by the accused in the court below, the same shall be considered having regard to the date of posting of the case. That interim order will.
Your Lordship, may kindly permit that interim order to me also.
Yes, same case is.
My
same
lord,
case only.
they are the petitioners. In this case, they are the petitioners.
Same case, same FIR.
No, same.
My lord,
Huh?
Same-
same.
Yes,
same
Same
case,
FIR is,
but liberty is given to them to move the time petition.
If
See the FIR which is law,
same, they are-
he
Yes, yes,
is
yes.
asking for quashing of that,
that is
and he is not satisfied with the investigation.
Yes,
My lord.
Your
FIR is same.
Same,
There is an
same.
interim order.
same.
In both the case, same interim order.
Yes, your Lordship.
Same interim.
Obliged.
Why don't you settle it?
We have taken all endeavors, Your Lordship, and if Your Lordship may
Shall I
kindly
send both of you to mediation?
oblige, Your Lordship.
My-
Your Lordship may make an order to
Give a try, don't spoil that.
oblige. Your-
My lord, with respect, my lord, I have left no stone unturned.
But go to mediation, what is the problem?
My lord, no difficulty. We
Go to
have,
mediation, if see, a settlement can take place within seconds. It may not take place for years together.
there were
So
two,
meeting of mind made,
Yes.
you know, you can change your mind anytime.
Yes, yes, yes.
Go to, the order will be remain like that. In the meantime, you go to mediation.
You'll also may
Because all
pass
the
that.
parties
Your
are there.
Lordship, unless
You'll
Your
also may
Lord-
pass that order.
Yes.
Your
Because
Lordship,
earlier
unless Your
this order
Lordship
was there.
passes an order.
I will
it
pass an order, that's what.
Obliged, Your Lordship.
See, in both the matters,
Both the
the first item, before the first in the first item, look, the petitioner is the informant in this case, and she is seeking intervention of this court, intervention of the court, because her application under section for her prayer for further investigation in the matter has been turned down by the court below. Whereas in the second matter, the petitioners, being the accused persons, are seeking quashing of the entire FIR. So the present case is the dispute is arising out of a matrimonial discord. Since all the parties are present, since all the parties are represented in this matter, I have on the query of the court, the legal counsel fairly submits that they can very well try to try for settlement, and accordingly they will advise their client. In the foregoing circumstances, I feel it appropriate to refer the matter to the mediation cell of the High Court, and direct the parties to appear before the mediation cell, and try to and endeavor to settle the dispute amicably, into awaiting the report of mediation. The matter is posted to stand over to give a date. Go and participate. Let us see. Otherwise,
So may fix up a date so that they both will appear.
when can you go?
your Lordship may kindly fix 1 week after any date will appear before the coordinator mediation.
The parties would appear before the coordinator of mediation cell on today is
7th,
today is
21.
5th, na? Today is 5th.
21.
Let it be on 12th.
My lord,
12th.
my lord.
12th. Okay.
Obliged, Your Lordship.
Date you give it on March. Advise them, and at least that lady will be free from.
My lord, I have agreed. The honorable court in the final bail application directed that you restore that room to her.
Yeah, I'll tell you, if I'll allow your petition, it will be aggravated.
Aggravated,
If
my
I'll quash it, that is also you lose it. So it's better that you settle it.
My lord, even on today, your Lordship, I am submitting, I have no dispute with them. If they will not,
Fair chance of settlement then.
if they will not do these acts, throwing my things, breaking lock in front of my house,
You can,
I'm staying there with my son, your lordship. I have
See
got,
that all the things which were thrown out, all those things will be given to you, the certificate.
let them do that, your
Your
lordship.
Lordship, had there been any veracity in the allegation, Your Lordship, the thing would have been returned either by us or by the IO. Let the investigation is taking the course.
Anyway,
the reason-
you should advise your client to settle it.
Obliged, Your Lordship. That
That is the
that
best
we've tried
best
also.
service you all of us can give.
Yes, Your Lordship. Much endeavor has been taken. We'll take further.
Please do that.
efforts. Obliged, Your Lordship.
Both the matter. Common order, huh? Yes.
17.
Made, please, your lordship. My lord, in item 17, your lordship, I am challenging the order dated 10/10/2023 as per annexure 5, page 22, wherein my application under section 205 to dispense with my personal attendance has been
What is the
dispensed.
offense?
My lord, the offense is under section 427 by
And
4,
447.
all summons.
What are you?
My lord, I am a special caste contractor staying in Raipur.
Jaipur.
My lord, your lordship may kindly see annexure 4, page 20. It is a summons case, 41A,
Chhattisgarh is about 350 kilometers away from
350 kilometers away from
the ground
court.
of land.
And I have been released by the IO under section 41A during investigation.
That's right.
I have cooperated throughout investigation. And your lordship may kindly see.
But as and when required, you have
Yes,
to come.
yes, that I undertaken. That I have undertaken. My lord.
Yes.
The petitioner, in this petitioner challenged the order dated 10/10/2023, whereby his application under 205 CRPC has been rejected. Full subject, Mr. Mishra, Land Council for the petitioner submits that the petitioner is a resident of Raipur, Chhattisgarh, which is about 350 kilometers away from the court in which the proceeding is being pending. The matter, the trial is pending before the court of JMFC. What is this?
Thuamul Rampur.
Huh?
Thuamul Rampur.
Huh?
Thuamul Rampur.
Thuamul Rampur.
Thuamul Rampur.
In city case number 44 of 2019 under section 427/447 of IPC. Mr. Mishra undertakes that his client, Mr. Mishra on instruction, undertakes that his client would be appearing before the court physically as and when he is required by the court. Taking into consideration the facts and submission at the bar, the order dated 10/10/2023 passed by JMFC so-and-so in CTK so-and-so is modified to the extent that the application for the petitioner under section 205 CRPC may be favorably decided, modified to the extent that the set aside and the court of JMFC so-and-so is directed to decide the application of the petitioner under 205 CRPC favorably taking into consideration the undertaking given by the Land Council before this court.
My lord, obliged, your lord.
Agent, when you require, you appear.
My lord, I'll file an application within 15 days.
You file whenever you file.
My lord, obliged.
Yes.
18.
Belgium matter, my lord.
Belgium.
My
You are
lord.
on bail.
My lord.
You are on bail.
No, my lord.
Absconding.
No, absolutely. Lately, my lord, support from.
Sorry.
Bail ಆಗಿರ್ತಿಲ್ವ ಈಗ all along this petition was on bail, but if subsequently due to some multiple disease she could not appear, for which that NBW has been
In
issued.
this case, your client was on bail or not?
My lord.
Was on bail.
My lord.
I'm asking whether in this case your client was on bail or not.
He was on bail.
On bail, no?
My lord.
And then when the NBW was issued?
5/8/2023. 5/8/2023.
500.
Obliged.
And appear on or before yes, 15th of 25th of February. 25th, so 25th.
Published.
500.
Published.
Okay.
Published.
19.
May I please your lordship? The question of individual dated 3/1.
NBW, you were on
He
bail.
was on bail by this court's order, my lord, on BLAPL number 1894 of 2018.
Dated
BLAPL number 1894 of 2018.
date of the order.
Date of the order 5/8/2018.
NBW
Enrolled dated 3/1/2021.
311.
3/11, sorry, man.
3/11,
2000.
21 you are coming, 1000.
My lord, labor class, labor.
500.
My lord, another thing, my lord, the NBW issued by the JMFC Rural, my lord. Now the case is pending before the JMFC Coordination Taking Court 2.
I'm setting aside, that's all. You won't appear before 25th. He will appear before the court on and before 25th of February, before the court of
Before the JMFC Coordination Taking Court 2. Cuttack.
Taking court to
Cuttack.
and await remedy.
Hon'Ble.
20.
Item 20 Belgium matter mail. Petitioners are relieved on bail.
Bail, you were on bail
21/8/2007 mail.
21/8/2007.
NBW was issued on 30/10/2000.
21.
Speak little louder.
21/8/2007.
Okay. And NBW issued on
30/10/2023.
500. Okay. Same date, 25th. Keep it. Yes. And they will remedy under law. Yes.
21.
21 also.
Same.
Then on 21/8/2007, but NBW are issued on 6/11/2023. 21/8/2007. NBW issued on 6/11/2023.
6/11/2023. 500.
22.
In this case, this Hon'Ble court had earlier directed the petitioner to appear before the in a bail application directed the petitioner to move to appear before the arresting officers, investigating officer, and directed him to release him on bail. Accordingly, he produced the certified copy of this order. Thereafter, he, according to direction of the, he cooperated with the investigation, and his vehicle, this is a forest case, my lord. His vehicle was seized. This Hon'Ble court directed the confiscation officer to take a decision earlier. Confiscation officer take a decision to release the tractor. Despite that order, my lord did not release. Again, he had to come before this Hon'Ble court. The range officer did not. Then this Hon'Ble court directed to therefore to take action against that range officer. Range officer, my lord, release the vehicle. My lord, thereafter, filed the charge sheet, my lord, after showing him as an absconder, my lord. That's why the NBW has been issued. Forest officer offense, my lord, both the offenses are 1656.
So anyway, NBW is issued. Why so many things?
My lord, 50. My lord,
You are on bail.
Bail.
You are on bail. When the bail was?
Who bail don't see ordered?
no, arresting officer with the
Don't see ordered.
Where is that anticipatory bail?
16,
Date, tell me date.
Date, my lord, your lord. False. In 2016, my lord.
Give the date and appear before the court
My lord, my lord.
by 25th and pay 1,000 rupees.
My lord, 1,000. My lord, date, my lord. 29/8/2016.
29/8/2016. 29/8 bail.
My lord.
Bail 29/8/2000 and NBW के भेला?
NBW 29/8/2016.
हाँ?
29/8/2016.
2016.
NBW.
I am talking about bail. When the bail you got? When you got the bail?
My lord, before the arresting officer, I produced the certified copy, and also, my lord, in the
You are not able to follow.
ଆପଣ କିଛି ଠିକରେ କହିନି ଏ ଲର୍ଡସିପ ମେ କାହିଁକି
ଆପଣ bail
Wait, he will assist.
BLAPL number 22107 of 2014.
Right. BLAPL number
22107 of 2014. Granted bail on 16/12/2014.
ठीक है. And NBW was issued on
16, my lord.
or 29/8/2016. Okay, NBW. He will appear before the court below on 25th, 1,000 cost. 1,000 pay cost.
Item 23,
Yes.
23,
Gotcha.
24,
Yes.
May I please, Your Lordship? That the petition seeking recall of the distress warrant dated 21/8/2023, Your Lordship, passed by the JMFC Chandikol in his execution case number 53 of 2023. Fact remains, Your Lordship, the present petition is the husband, and the marriage took place on 29/4/17. And the
By this order, what happened to you?
my lords,
By this order,
the
21/8/2023.
DW, page 24, Your Lordship. Order 21/8/2023, last part, Your Lordship. In the given circumstance, there is no other option but issue DW for relation of rupees 41,000 from the OP1. Issue DW against the OP1, Your Lordship. And the IIC Dharmasala for relation of the aforesaid amount put upon it.
Yes.
The case, Your Lordship, the marriage took place in 2017. Thereafter, Your Lordship, the OP2, son born on 2018, 27/3/2018. And the wife left the house of the petitioner since 30th/1/2021, Your Lordship. And thereafter in 2022, 23/12/2022, the DV miscase was filed before the court below. And on 23/12/2023, Your Lordship, expiry order was passed. And the present petition was directed to
But
pay.
whatever, there is an order.
Yes, Your Lordship.
This application is not maintained. Application is not maintained.
Please, let me place.
ଆପଣ ପ୍ଲେସ୍ କରିବେ ଯେ ଆଗେ ଏଇଟା ମେଣ୍ଟେନେବଲ ଉପରେ କୁହନ୍ତୁ।
See, there is an order, you have to comply. Simple.
Yes, Your Lordship. I'm coming.
Otherwise, you get it modified. That order 5.
My Lordship.
ଏଇଟା 482 ହବନି?
Naturally.
I am coming, Your Lordship. I'm placing. Let me be submit, Your Lordship. Kindly.
First meet his objection.
Yes, Your Lordship. I am not challenging that order, Your Lordship.
What are
So far, my learning senior submitting. So far, if I am challenging that order, then appeal is lies before the learning session judge. Here, I am not challenging the order, Your Lordship.
What are you challenging?
Yes, Your Lordship. I am coming, Your Lordship. Only two, 3 lines, Your Lordship. After the expiry order has been passed, the wife and son both filed execution application before the learning court below. Thereafter, Your Lordship, during pendency of the execution application, unfortunately, the wife died. After leaving me, she married another person, Your Lordship, and she was pregnant. And during pregnancy complication, she died in the SCB
What is the
hospital.
relevancy of these facts?
My Lordship, on 19/6/2023, she died, Your Lordship. Wife died. Now my only son is with the maternal grandfather. And the after death of the wife, Your Lordship, the learned advocate not communicated to the learned court below. And after her death, this order has been passed. Now I am ready and willing to take back my son, Your Lordship. And
All this thing in this proceeding.
yes,
what are you
only
talking? You need custody, you need everything in this proceeding.
the matter also settled. ସେମାନେ ବି ରାଜି ଅଛନ୍ତି ଛୁଆକୁ ଛାଡିବା ପାଇଁ, କିନ୍ତୁ କୋର୍ଟ my humble prayer, Your Lordship, ତଳ କୋର୍ଟରେ ସିଏ କହୁଛନ୍ତି ଯେ ଯେହେତୁ ଡିଷ୍ଟ୍ରେସ୍ ୱାରେଣ୍ଟ ମୁଁ କରିଛି, ମୁଁ ତାକୁ ରିକଲ୍ କରିପାରିବିନି। ଏ ଲର୍ଡସିପ୍ ଖାଲି ଡିଷ୍ଟ୍ରେସ୍ ୱାରେଣ୍ଟ ରିକଲ୍ କରାଉ ସବଜେକ୍ଟ ଟୁ ପେମେଣ୍ଟ ଅଫ ଦ୍ୟାଟ୍ ଆମାଉଣ୍ଟ। ମୋର
You will pay 41,000.
yes, Your Lordship. I am
And go and
yes, ମୁଁ ସରେଣ୍ଡର କରିବି, ସେ ଖାଲି ୱାରେଣ୍ଟ ରିକଲ୍ ହବ। That is my sole
ଆଉ ଏତେ
prayer.
ଏମିତି ବୁଲେଇ କୁଆଡେ ନେଉଛନ୍ତି constitutional.
ଭାଇ କହୁଛନ୍ତି maintainable
I'll pay and I'll go and
yes,
we
Your
can't
Lordship.
object also.
That is only the prayer, Your Lordship.
But ଆପଣ ଏମିତି ବୁଲେଇ ନେଇକି ଦୁନିଆର
No.
କାହାଣୀ କହିଚାରିଲେ।
My Lordship.
The learned counsel for the by way of this petition, the petitioner is challenging the order dated 21/8/2023, whereby the warrant has been issued for having not complied the order of maintenance passed in favor of the opposite party. He submits that subject to his depositing the area maintenance amount of 41,000, the warrant issued against him may be recalled. taking into consideration the submission made at the bar, subject to petitioner depositing the area maintenance amount of rupees 41,000 with the court below, the order issuing the warrants against the petitioner is set aside. Petitioner is directed to appear before the court below on or before 25th of February. February and tender the area amount before the court and seek appropriate move appropriate application for the other relief. He is praying before the
Obliged.
insofar as other reliefs are concerned.
My lord.
You move 41,000 you pay and
Yes, sir.
In the first line, your lordship may indicate in a DB proceeding. In a DB proceeding, maintenance has been.
in a DB proceeding, the maintenance order in a DB proceeding.
Yes. Obliged.
25.
Yeah, previous madam. In this case, I am challenging the complaint case of highly under 138 NI Act, my lord, which was returned.
You are accused.
I am the accused.
Yes.
I have returned after 5 years of taking cognizance, and in meantime, one witness has been adjourned and cross-adjourned, my lord. Thereafter, the court has returned the file due to on ground of the jurisdiction, my lord. As per the jurisdiction,
You are the accused, huh?
Yes, ma'am.
Then what do you want?
That on the jurisdiction ground, that the court has the power to transfer the case to the original jurisdiction, ma'am, as per the provision contained in the 142A, ma'am. As per the amendment.
Impugn order is?
Impugn order, ma'am, 33, page 33.
33.
Order dated.
Where is it?
30/10/2023, ma'am.
30, which page you said? 31.
33, my lord, that page order started, ma'am.
33, huh?
Yes, ma'am.
Okay. Read it.
I am reading in last line, my lord. 30.
That is 30th October 2023.
Yes, ma'am.
The record is placed before today for filing objections, petition or so filed by accused.
Not from the both sides, my lord.
Heard
Where
both
was the
sides,
case?
there is record and this is the case.
This case
The checking question has been drawn from HBI sector 2. When CDA got up, according to the complaint petition, the check is question has been presented before the way for collections.
Outside this court's jurisdiction.
Transactions have done outside federal jurisdiction. Okay. Federal jurisdiction. Now this judgment has come, na?
Yes, ma'am. Judgment is come.
Then what do you want?
Jurisdiction you have the judge was in case
the exercise of 200 CRPC offense is directed to it, send the complaint to the complainant for. He has written it, you present it.
Yes, ma'am. My responsibility.
You are the accused.
After 5 years, manner, examining the one witnesses, the case was maybe transported to the original jurisdiction, but who has returned?
I think the complainant should have made the grievance. You are the accused.
I am the accused. Complainant has not filed any petition, but the suo motu, the magistrate has returned this case.
But then you should be happy.
No, madam. My case has, in meantime, the limitation is only one month, madam. As per the provision of the 201 CRPC, limitation only 1 month. The order passed in 30/10/2023. The limitation already passed, madam, to present a fresh case at the jurisdiction court of which.
No, this will be set up because it was prosecuted in a wrong court.
Yes, ma'am.
Under section 14, it will be set up.
So only for
what is your grievance? I am not able to follow.
My lord, as per the decision of the Honorable Supreme Court, my lord, those cases was in pre-summons stage. Only summon has been issued. The accused has not appeared before this court of where the case was pending. Then the case was returned to the complaint for file in the territorial jurisdiction where the court was situated, my lord. But in this case, the
evidence was going on. So this grievance, the complainant should make the grievance. Why are you making as an accused? Complainant should have said that, see, this is an advanced stage, and now
I am the complainant. Sorry, madam. I am the sorry, madam.
ଆପଣ ପୁରା ରାମାୟଣ ପୁରା ପଢିଦେଲେ
ଉଲ୍ଟା
ଆପଣ
ହେଇଗଲା।
ଜାଣିନାହାନ୍ତି କାହା ପାଇଁ ପିରୁଛୁ।
उल्टा है वाला देखिए
That is why I was wondering.
madam.
I asked many times, why are you accused?
Sorry, my lord.
You are competent to tell that.
Yes, ma'am, I am the complainant, ma'am.
Order direction already given.
No, what he says that I thought I kept on asking whether you accused. He said accused. That is what I was saying.
Sorry, ma'am.
So if the complainant, he says that in the advanced stage, see, pre-summoning evidence, it could have been written. After summoning,
Yes, ma'am.
witnesses are examined. At that time, you say that take it and present somewhere else.
Yes, ma'am.
That is why he agree. That's what you want
Yes,
to say.
yes, ma'am.
Now you are sure that you are for
I am
complaint?
complainant, ma'am. Complainant.
Check it up.
Yes, ma'am. I am sure.
Take your file.
I am sure, my lord. I am complaint person is unnecessary, my lord.
So I'll issue notice. Opposite
Yes,
party.
two.
Notice
Unnecessary.
Notice. Opposite party number. When counsel for the petitioner submits that the petitioner is the complainant in the ICC case number so and so under section 138 NIA. He submits that when the complaint was at an advanced stage, the trial court by the impugn order has directed him to the trial court by the impugn order returned the complaint to be presented before the competent court on the ground that the trial court doesn't have the territorial jurisdiction. He is agreed by the order to the extent that since the complaint is the prosecution of the complaint is in an advanced stage and witnesses are being examined. At that stage, the complaint ought not to have been returned to him for representation before the competent court. Issue notice to the opposite party number to retain good.
Opposite party number 2.
Opposite party. Okay. See, if you don't know for whom, how much
Sorry,
time we
ma'am.
get.
It's due to duty. Oh, my.
Anyway.
ଖାଇନି ସକାଳୁ ପଳେଇ
I'm confident he goes to yes.
କାଲି ହବ କାଲି
Yes.
26.
26.
My lord, earlier bail on 19/5/2023.
Sorry?
Earlier I was bail on, my lord.
Okay. NBW issued on?
NBW issued on 10/1/2024.
500.
My lord, only
bail date ଟା কোন bail date ଟା
bail date, my lord, 19/5/2023.
19/5/2023. NBW 10/1/2024. 500. 500.
My lord, my 317 petition has been rejected, my lord.
5 ଟଙ୍କା ଦବ ବା ଆଜ୍ଞା
5 ଟଙ୍କା ଦେଇକି ଆପଣ ଯାଆନ୍ତୁ।
Only my predicament is the petition is staying at a long distance.
That I'm not going to. You move application.
My lordship.
19.
Yes, my lordship. I have a defect can be ignored. My lordship, I seek for a passover after lunch. My learned senior will be.
Okay, okay, pass over.
20, 29.
29.
Maybe.
Yes.
Here a young boy of 21 years, now 22 years, who is married to the girl, is now before Sonal Court for a blessing for the quashing of the investigation because of the fact that they have married to each other and the girl is also leading a happy conjugal life with the present petitioner. Last time the Sonal Court has invited me to have my appearance and accordingly they have come.
My lord, I am on behalf of the victim, my lord.
What about Poksho?
17 years, 10 months.
What happened in this case, you also directed the victim as also his mother or informant to appear through police station. But mother might not do notice made sufficient of the mother, but could not serve notice on the victim since he was residing.
She was virtually.
Mother is not there, na?
Mother is not, but the I also might direct to appear virtually. Link not to
same problem. Link the below last time also the same thing.
So
9th kontu.
9th.
9th kontu. 9th kontu at 10:30 exact.
Or say Olga could play this. At 9th.
9th re exact at 10:30 you say, so that there will be no confusion.
But all the matters are
all the matters, but this matter at exactly first item. Even if it is listed in any other item, you please mention it. First item we will take it up. 9th.
My lord, may record the appearance of the.
Pursuant to the direction of this court, dated. Dated.
Number 3 up here.
5/1/2024. The
accidental link the picture.
Yes. The IO is there. On karo. The what is his name? Yes. What is your name? Yes.
Jugal Sabar.
Jugal Sabar. Pursuant to the order 5/1/2024, the IO of the case, which is due to SI or IIC.
Inspector sir,
IIC of which, sir, now, Mr.
Kodinga Police Station.
Jugolo Sabar of Kodinga PS has appeared. The petitioner and the
OP number 3,
the victim girl are present in the court today.
I'll affidavit. Question to the IO.
Again, the petitioner, my lord, in connection with JR case number 503 of 2023.
What happened? NBW?
My lord, that is the my lord challenge the quashing of FIR, my lord.
Quashing of FIR?
And continuance of investigation against the petitioner, my lord.
I can't stop investigation.
But what happened, lordship, may kindly see the FIR I have annexed.
Yes. You are so hurried. Wait till the investigation is completed.
My lord, what happened, my lord?
In the 376 matter, and you want the FIR to be quashed at the very instance of registration.
It is, my lord, now, my lord, it is registered in the
whatever investigation is on, sir. I can't stop investigation. Let it complete. You withdraw it. Reserve your right to come at the appropriate stage. Who knows? They may file final report. Whatever defense you have, go and tell the police. They may file a final report also.
Small, it may be adjourned, my lord.
Why adjourn?
Why am
the counsel for the petitioner seeks to withdraw this petition, being premature, reserving his rights to approach this court at appropriate stage.
May I say one thing? One thing I pray, my lord. If lordship not satisfied with, I pray, my lord, only first half, second time may be surrendered. If, my lord, that may be given.
This is the bail court.
What happened in the
no
10 years back?
No shortcuts.
What happened?
No shortcut. It is only 482 for quashing.
My lord.
And it is at the investigation stage.
10 years back,
investigation is going on. You pursue remedy, whatever remedy you have.
10 years back, occurrence has been taken place.
That's good ground for getting bail. Go to bail court. Not 482 court. Okay, next.
Withdraw
Next.
kar deji, please.
File को withdraw कर certificate.
It is a better case for quashing.
Oh, yes, I know.
It is a better case for quashing, so you.
Better case for quashing, but not better case for bail. Very good. Chalo, I have given the liberty. Don't.
Obliged.
Yes. 30?
34.
Yes.
For Lordship, may please be allowed to.
Yes.
Here I have filed this 482 application seeking quashing of the FIR.
Yes.
Which is full of absurdity. May I take your Lordship to the formal FIR? That is
What is the stage? What is the stage?
That stage can my learned friend apprise.
Today, just now,
But investigation is still on?
Since it's a case of 2000, November 2022, neither I can say yes or no. Not in a
No,
position.
what are the offenses?
Right, the offenses are 294, 427, 436.
But these offenses, why are you taking so much of time?
Just now, I already given the
Now you got it, but why? What the police is doing? 2022 and no investigation, nothing.
Let them say at least this might
Not
have been.
such a serious cases.
And the FIR is full of absurdity. The incident of July detected in September, reported in November.
That perhaps the reason the police is confused. They want to file a final report in your favor.
And that too.
Wait till then.
What judgment
is 19-year-old boy, my lord, is
What is this judgment?
Judgment, my lord, the very same informant family has lodged one FIR earlier. They were acquitted on 19/6. Now they allege June. They allege in July we have again committed one offense. Again in September 1. So all this. And
this is the earlier FIR, huh?
This is the earlier affair. Just after 1 month after being acquitted, another, and that too what? Now he was coming near to our land. On being caught hold, he said he has done something in the month of July. And even then, it was reported after 38 days. Police has without even, there is preliminary inquiries.
You are absolutely correct. But the only problem is it is at the stage of investigation.
Let my friend take instruction. Till then, I may be protected or no coercive action. Because
no.
This 19-year-old boy, your lordship may.
Whatever, but I will put it in next week and seek instruction. Next week, huh? Put it on 12th or 13th. 12th or 13th. Seek instruction. What is the stage of the investigation? And tell me. 13.
Deeply okay.
13, okay.
35.
Please, my lord.
Yes.
Lords, here an order of cognizance at Annexure 1 is under challenge. The facts are like this, my lords. An FIR was lodged against the petitioner on 21/2022, my lords. And it was registered under 376(2)(n), 294 and 506 IPC. He had challenged this FIR in this honorable court, my lords, in a CRL MP. That is CRL MP 523 of 2022. Investigation which was taken up into the FIR, my lords, has culminated in the filing of a charge sheet, which is at page 11, and by order dated 30/3/2023, the court has taken cognizance of offences under 376(2)(n), 294 and 506 IPC.
Right.
My lords, the CRL MP which was heard, my lords, has since been disposed of, and this court has been pleased to quash the FIR so far as the offence under 376(2)(n) is concerned.
Okay.
So
then what remains? 294 and 506.
294 and 506 remain. So the order of cognizance to that extent has to be quashed.
That I have not supplied the copy matter. But I have seen that the copy matter and see last portion of 2-3 lines matter of the copy matter specifically mention the liberty given to trial court matter. This honorable court matter. while passing the offense under 376(2)(n, directly court below to verify and examine, my lord. I'm reading out my lord last portion.
But so far as 376(2)(n) is concerned, that has been passed.
Therefore, offense under section 372(n) of IPC so far present petitioner is concerned is hereby quashed. With regards to allegations under other sections of IPC, it is open to the trial court to come to a just and a fair conclusion after conducting the full present trial by taking evidence from both the sides. Further, it is also open to the trial court to critically examine the allegations made in the affair and taking into consideration statement of the witnesses accordingly the charge may be verified and modified in the event of a appears.
Once it is quashed, then what do you want now?
Quashed, my lord, so
Now, this
Other offenses, you have challenged the entire thing, and now the court says that only 276(n) will be quashed and the other thing will remain.
My lordship, your lordship may see what.
Can I sit over the appeal about this order?
No, I am not asking your lordship to sit over it in appeal. Your lordship may see the date of this order. The CRLMP's order, my lords, is on
2nd November.
On 2/11/2023. Before that, my lords, Annexure 1 has been passed on 30/3/2023, my lords. So this Annexure 1, the court there, it cannot go back and recall it. So your lordship has now to say that the order of cognizance at Annexure 1, so far as it relates to the offence under 376(2)(n), should stand quashed in view of the CRLMP judgment.
Technically.
That is what your lordship has.
He's not asking the other offence.
All the aspects are taken into consideration by the coordinate bench.
Who denies that? Who denies that? But the law is that the court has no inherent power.
The fact remains, see, the High Court passes an order on 2nd of November 2023 saying that 276(2)(n) is not made out. Thereafter, on 30th March 2023, the court has taken cognizance.
That is much before that.
So that part has to go.
For that reason, my lord, this honorable court, it is open to the trial court to come to a just and a fair.
हमें कौन 290/506
সেটা কইছে তে পিওরসি নেট পাত
अरे हमें कौन 290/506 কথা এটি কହୁଛୁ ଆମେ କହୁଛୁ କେବଳ 376(2). ଆମେ ତ ଚିନ୍ତା କରୁଛୁ।
Petitioner, in this petition, the petitioner is challenging the order dated 30/3/2023, whereby the trial court, the court below has taken the JMFC
Rajgangpur
has taken cognizance of offence under section
376(2)(n)/294/506 IPC.
Next program. Mr. Panda submits that at the threshold, the petitioner has approached this court by filing CRLMC number 4090 of 2023, seeking quashing up the FIR.
Question of the cognizance, my lord.
Earlier you came for the coordinate bench of this court by its detailed order dated 2/11/2023 came to the conclusion that insofar as the petitioner is concerned, no case under 376(2)(n) is made out. Therefore,
the same is quashed.
Pass the FIR vis-a-vis the allegation under 376(2)(n) is concerned. The relevant part of the order or judgment. This is
the judgment.
Relevant part of the judgment is para 22.
Page 22, para 22.
Para 22. Mr. Panda further submits that since the coordinate bench has passed the order on 2/11/2023 and subsequently
and prior to that the cognizance has been
prior to that the cognizance has already been taken.
By Annexure 1.
Therefore, he has invoked the jurisdiction of this court under 482 CRPC for quashing of the cognizance order insofar as the offense, so far
376
taking
2N.
taking cognizance of, for the offense, 376 2N is concerned. Accordingly, the cognizance order is cognizance order dated 30th 3/2023 is set aside to the extent that the offense, the cognizance of offense under 376 2N is concerned. And remaining. 36. Yes.
36 Lordship, bail jump matter.
Bail jump. When you are in bail.
I was absent on 16/12.
Absent, forget. You are on bail?
Bail on 15/12/2017.
15/12/2017. NBW?
NBW issued on 16/12/2019.
19. 19 now you are coming. 1,000.
Yes.
1,000.
500.
Okay. And you will appear on or before 25th of February.
Let's say 500.
Why 500? 2019 you are coming.
Lady petitioner is a lady.
Whatever. I am just looking at when just see 2000 about 2 years. Go and surrender 1,000 rupees. Lady, see the lady.
Ladies. 23 years late. 23 years.
Make it 5. Lady. Yes.
37.
Yes.
Lords, can be excused.
Yes.
My learned friend is asking for an adjournment in 48.
48.
I have got some work. I will not be available.
So also grant me some time to file counter also. In that your lordship has directed me to file affidavit.
Mr. Agarwal, 48. Mr. Agarwal, 48. Mr. Agarwal seeks further time to file response to the petition filed by the petitioner. Accordingly, the matter is stand over to which date? Which date?
3 weeks your lordship.
You tell me the date. I'll fix a date, no? Let it be on 15th of March. 15th March.
Can it be 18th of March?
18th March. Okay, 18th March.
Entry order.
Entry order to continue. Once you get the interim order, that's the problem.
Not an interim order. Actually, your lordship has directed him to appear through this. That is the only order. So that it is we are not going to arrest him unless your lordship. When we know that matter is pending before this court, we are not going to take any step unless your lordship decides.
This order is only a protection against me, so far as the court is concerned.
Yes.
Is a case mailer.
30?
The informant is before a lordship. Informant with the injured mailer before a lordship mailer. Though the informant victim mailer sustain mail vital part of the injury on vital part of the body mailer, there is a head mailer, but the concerned police has not added 307 mail, only 506 and 325.
It is at the investigating
stage. The lordship at the I'll take instruction whether this in the matter.
What instruction? FIR is lodged in some section.
Has been submitted or not. I'll take instruction.
He knows it. If it is submitted or not submitted, can the court add the provisions?
No. The injured man sustain vital part, sustain injury in the vital part of the organ mail, the head mail. But the police.
Learn counsel for the petitioner. Petitioner has filed the present petition. Inter alia praying that in the FIR, offense under section 307 IPC has not been added, despite the fact that the informant oblique the injured who is petitioner has received serious injury on his head. Full stop. Next paragraph. The case is at the investigation stage. Therefore, the court cannot exercise jurisdiction under 482 to grant any relief to the petitioner at this stage. Therefore, the petitioner is disposed of as premature, reserving right of the petitioner to approach if approach at appropriate stage if cause of action survives.
Right, Lordship, next week I'll be with
No, no, I have
completed
fixed
charge sheet file. I'll produce.
I have given everything.
Oh.
Yes. Yes.
39.
Yes.
Not pressed.
Not pressed. This is the best argument.
No. There is a development.
Okay.
Charge sheet file and
Yes.
bill.
Next.
42.
42. 42? Yes.
There is a defect. Kindly grant 1 week time to remove the defect.
Adjourn. Adjourn. Yes.
43.
Pass over.
44.
And item 44, 3 days time will be able to for removal of the defect and taken on Monday, my lord.
Okay. We adjourn.
45.
May please, madam. Here is a case, my lord, where the judgment of the apex court in Bhajanal case is squarely applicable on the ground that the particular affair has been lodged only because of to previous gross and all such things, my lord. The allegation has come up with this, my lord. And this small affair, I am just placing for my kind appreciation. Page 7. विषय स्वाधीनता दिवस पताका उत्तोलन समय धूमा भणी बीणा पाणी सचन सच महाविद्यालय आईन को अवमानना कर स्वाधीनता संग्रामी मान जय गान और जातीय संगीत गान करने परिवर्ते महाविद्यालय अध्यक्ष निर्देशक में अध्यक्ष अध्यापक प्रत्यक्ष उपस्थिति बोलबम नारा देउथिबारु अध्यक्ष अध्यापक गिरफ कर दृढ़ कार्यानुष्ठान ग्रहण करने महाशय आम्बे कोशल राइज मुक्ति मोर्चा बलांगीर बेलपड़ा ब्लॉक कर्मकर्ता अटू गत 15/8/2023 भारत वर्ष स्वाधीनता संग्रामी महाआडंबर पालित होइछि। सेही दिन बलांगीर जिला बेलपड़ा ब्लॉक अंतर्गत धुमाल स्थित बीणापाणी डिग्री महाविद्यालय मध्य स्वाधीनता दिवस पालन कराइथिला। किंतु दुखर विषय पताका उत्तोलन समय महाविद्यालय अध्यक्ष श्रीयुक्त सचेत पिटसन दांक अध्यक्षतार अध्यापक अरुण दुबे उपस्थिति अनुष्ठित होता पताका उत्तोलन समय अध्यक्ष निर्देश क्रमे भारतीय संविधान को अवमानना करी स्वाधीनता संग्रामी स्मृति चरण जय गान और जातीय संगीत गान करने परिवर्ते फ्लैग कोड नियम को उल्लंघन करी
प्रिंसिपल
प्रिंसिपल एंड लेक्चरर
these people are doing all this kind of
but my humble I am just placing that there
want to create a khalistan here
no not that way किछि से रही संविधान अवमानना करी स्वाधीनता संग्रामी मान स्मृति चरण आगे सरी ओटी खाली स्मृति चारण और जय गान जातीय संगीत गान करने परिवर्ते फ्लैग कोड नियम उल्लंघन करी पवित्र दिवस गणेश पिता पार करेगा पार्वती पति पार करेगा गणेश पार करेगा
गणेश
फादर पार करेगा पार्वती
हस्बैंड पार करेगा नारा दे भारत
करी नारा दे भारत
should not encourage these people
मात्र भारत को 144 कोटी को
at least this our state is so peaceful state if you encourage this kind of people and then we will
no my humble submission some seven accept this allegation it requires a support corroboration matter if there is a single corroboration by any person
corroboration premature
no my friend got this CD malady
no
premature state and this
then when I mean
withdraw
withdraw is something different right? That my humble submission the particular affair must constitute an offense my lord
what offense sir
that they will look into
no when they have registered a case my lord now it is
they might have invoked wrong provision investigation thereafter they can find out
yes my lord that's
their allegation
no because of by registering a case against me register a case against me and because of this affair who has lodged the affair my lord not any authority and that particular when the things was there the sub collector
I will not
no my humble submission the sub collector himself was there. That's why my humble submission because the fact that at the relevant time sub collector was there along with other officers of the particular because the college every other person private management college other persons were there but I was also there and now the affair has been lodged only against me affair has been registered only
they may find out more
no that is exactly my case my humble submission
that is the duty of the investigator sir
I do consider that but when a affair has been registered my lord that's why when a affair has been registered it requires the constitution of the offense passed. And thereafter, my lord, the investigation is in the meantime it has been come up to this extent that the subject was there, his statement has everything has been recorded. Now still then the case is there.
All these things they'll look
The
into.
No, they are not looking after, my lord. They are not looking after. And these things, whether it has been made or not, who will accept the statement of this particular person, it requires the corroboration of all the persons. The sub collector.
We don't know
After
what is
investigation,
happening in
corroboration will come.
Once the charge sheet is filed, you have the, you can.
You
That,
have to say
I don't
corroboration
dispute
or
that prerogative I have, but that prerogative I have, but this the offense must be considered, my lord.
Do you want the liberty or simply will withdraw?
Madam, I take it on Monday, my lord, I will further argue and to further
No,
argue.
I will dispose it. I will not keep furniture.
My lord, the beer,
I understand it. I am protecting you to that extent that you.
No, my lord, my humble submission, if somebody will come.
What Monday is so auspicious that on Monday only.
I think no, because of the fact that I have not been prepared, madam, give me Monday, madam, I don't want to.
Preparation.
No, unless and until I be satisfied that I have placed before the matter.
These kind of petition I am not going to.
Yes, my lord, I do. My lord, whatever order want to pass, madam, I will pass it on Monday.
Pass the order right now. How can you see this? Our state is very peaceful state. If these kind of people are allowed, and you want to create a Khalistan here.
No, but what allegation, my lord? What is the allegation? No. My lord, a person has come up and make an allegation. Whatever absurd allegation can be believable.
You do all these things.
No. When it has been made, because everything has been my humble submission, everything has been taken care of. That this is recorded in the CCTV ballot. All things I will plus people. Whatever.
That is the part of the investigation that will taken care of.
I will dismiss it.
Yes, only Monday. Only Monday. No more. Only Monday.
Tomorrow.
No, I will not be, well, because of my younger father is expert, I will leave for 3-4 days.
So after lunch?
I see one day.
This matter has to be discussed.
Yes, my lord. My parthead also. I am ready for that, but on Monday. Only on Monday.
Parthead doesn't mean anything.
No.
This set of people should not be
I will try my best to convince the Salvo Court. If failed,
it's happening in JNU.
That
started here
with all respect, that particular slogan and this slogan is totally different.
This is slogan.
Nobody made
allegation in a Hindu god goddess's name. No Khalistan, my lord. Hindu god goddesses.
This Hindu gods in August 15.
Yes. What Monachi?
Nine. Ha, Chipra.
My humble submission, I keep it to Monday, I will try my best. I think I will get Monday.
Crores of people have given their bloods for the invaders of the day.
You disrespect.
And you are exploiting the country by the means.
By friendship.
Today's
these sorts of people, I am totally against this.
Put it on
otherwise.
8.
8 I will call and younger father is expert, I will not leave 6.
You have able juniors in the office.
I have to
give them opportunity.
No, I will not in this case because Violet has targeted. I will take it on 12th.
12th is very auspicious for you.
No, not auspicious. Every day is
okay.
Obliged.
I'll record it.
My lord.
I record your submission.
My lord. There is no need of. I will start my submission that my lord has put this question to me and.
I'll just. The petitioner has filed, invoked the petitioner has invoked the inherent jurisdiction of this court under 480 CRPC, inter alia challenging, inter alia seeking quashing of the FIR number so and so under section so and so. Mr. Chand contends that from the reading of the allegation in the FIR, no case is made out. No case is made out. The investigation is still on. And Mr. Maharaj enters appearance and submits that he would seek instruction regarding the status of the case. At this stage, Mr. Chand seeks an adjournment. Accordingly, the matter is adjourned to 12th of February.
Obliged.
You are looking for some different thing.
No, subtle, not.
All right. It's a part of it, what to do.
That is it.
46.
May please.
I got it. Yes. Next.
Here, my lord.
Which one? 46.
I get. Here the present petitioner and the opposite party, my lord, number 2.
Yes.
They have married to each other and they lead a happy conjugal life for some time. Again, some disturbance has arose.
Same.
Yes, my lord, we take it on 9th because although I will not be there, but POSCO is there.
You said in the other matter that you are there on 9th. Then why can't I take the earlier matter?
No,
also,
my lord.
fine?
I will all be there because of the fact that my lord has recorded, my associate can meet the purpose.
Okay. 9.
Yeah.
Next.
47.
Yes.
47
Sir, ଆମର ପରା time ଲାଗୁଛି ତମେ କରିବ କି?
ନାଇଁ ମୋର ଅଛି ଫାର୍ଷ୍ଟ ଆଇଟମ ଟା ଆପଣଙ୍କ
ଆଚ୍ଛା,
ସବ
ଆଚ୍ଛା, ଚଳେ।
Yes.
partition my lord, the NBW was issued 3rd January.
You are on bail?
January 2022.
You are on bail?
My lord?
You got the bail from the court?
Yes, sir.
Date?
Good bail nature
Date. Date
No,
of-
no, no, I am absconded.
Absconding.
Yes.
When will you appear in the court?
The date will be fixed in 17 February in the trial court also.
You appear. The land counsel for in this petitioner is challenging the order dated 3/1/2022 passed by the JMFC in so and so case number so and so whereby NBW has been issued against the petitioner for having absconded. The counsel for the petitioner submits that the next date appearing before the court is 17th of this month, and he undertakes to appear on that day and avail remedy under law on the basis of the submission.
All the 6 accused has
Basis
been
of
released on bail.
submission and submission at the bar. The operation of order dated, which order is that? Impugn order dated 3/1/2022 is kept in abeyance till 17th February 2024, and the petitioner is directed to appear on the same day and avail appropriate remedy under law. Yes. Disposal. Yes.
So far, sub-item is concerned, I play 1 week after, my lord.
What is this matter?
That is against the order of framing of charge, I have come. Rejection of order of framing of charge.
Okay. Adjourn. Yes.
49.
49, huh? Okay. What 48 is over, huh? Okay. 49. Yes.
49.
Yes.
My lord, order of cognizance under Annexure 2 at
Yes.
page 20 under challenge, your lordship,
Yes.
on the ground of compromise, my lord.
Settled.
My lord,
What is the offense? What is the offense?
my lord, offense. Now the opinion number 3 and petitioner is residing as husband and wife.
Married, huh?
Yes, your lordship.
Uh,
2 children.
Where are they?
Short date में faced for appearance.
Tomorrow, short test. Tomorrow, day after?
Tomorrow,
Day after?
your lordship may fix on 12th.
12.
12th.
12. Okay. 12. Shall I record your submission?
Yes, your lordship.
The petitioner, in the present petition, the petitioner is seeking passing up for the cognizance order dated 24/11/2025 passed by so and so, the section so and so. The counsel for the petitioner admits that the parties have now settled their dispute, and opposite petitioner is now married with opposite party number 3, and they are leading a happy marital life. In view of the said development, he seeks indulgence of this court for quashing up the entire proceeding. On advance notice, Mr. Das appears for opposite party and files Vokalatnama, which is taken on record. The parties would appear, they submit that the parties should appear before this court on
12th.
12th
February 2020.
Okay.
I have filed a miscase, if your lordship.
12th, nothing left. Yes.
50.
May I please, your lordship? My lord, NBW issued on 8/3/2019, my
On
lord,
bail?
page. My
You
lord,
are on bail?
my lord,
Date?
order copy. This is the order copy.
कौन लिखी है? पास
बेले जाए तो
हाँ
बेले बसला
thank you. Development taken place during the international. What is this?
Order copy of the
You are on
granted
bail,
bail.
huh?
My lord.
No, last order I passed, I have changed something here. In this petition will challenge the order dated from to pass with the legislation from to. NBW. You are on bail from. Bail 13/2/2019. NBW issued on 18/3/2019. Okay, 1,000. 1,000. Yes.
51. Please, my lords.
Yes.
The 482 application against this role of the father is absolutely not there. Save and accept the statement. किंतु पद्मनाभ पूजारी आउ जोगेश्वर पूजारी आम मानकु पुनर्बार तड़ी देले. Only statement against me. The son may have done something, but the father is 60-year-old man. Lordship, he has no role in it.
What the charge sheet says?
Charge sheet, my lords. Page 17. 294, 323.
Under the age of 34.
But my lords, 60-year-old man, my lords.
Let us see what is
506, 294, 323.
No, let us see what is the allegation against.
Well, it's in the FIR at page 10, lordships.
No, forget about FIR. Now it is culminated to a charge sheet. Then let us see the charge sheet allegation.
Page 20.
You are.
I am Padmanabh Pujari.
Pujari.
Well, it starts at page 21.
Name is Pujari. You are doing all this.
I am the father, lordships. I don't have any.
Let us see. Let us see the
allegation.
Yes. Padmanabh Pujari.
Page 22.
Yes.
Thereafter, Jogeshwar Pujari kept physical relationship with Gitanjali Naik, so and so. Now, when Gitanjali approached Jogeshwar for marriage, Jogeshwar Pujari abused and filthy language, assaulted her, threatened to kill in life. When Gitanjali along with went to the mother of house Jogeshwar Pujari.
376,
164,
2N has to go. And the other offences may, under the age of 34, you can.
Let us examine the one.
That part has to go.
Yes.
Because there is in the 161 statement also, she doesn't say that the father has done anything.
Save and accept
in so far as 376 2N is concerned. So that offence, I think we can think
376 2N.
2N.
376 2N against the main accused. Only against this petitioner 294, 323.
No.
506.
Yes, ma'am.
Charge sheet file. That is the
charge sheet against this accused only that.
Only 294, 506, 323.
Read with 34.
Lordship, like I said, that is why I was.
Let it come on 12th, Lordship.
Page 22, Lordship, may kindly see.
Okay, let us see 164. Let us understand.
Please, ma'am.
If those are the small offences, then we can let up this man. We'll see, examine. 164.
ଆପଣ ବି 164 ଆଣିବାକୁ ଚେଷ୍ଟା କରନ୍ତୁ
ଆପଣଙ୍କ ପାଖରେ ଯଦି ଅଛି
ମୁଁ କଲ୍ ଫର୍ କରିଦଉଛି
you call for and just examine
52 made to the lordship. Yes. Challenging the order of cognizance, lordship, kindly turn to page annexure 4, page 33.
4.
Annexure 4, page 33.
Yes.
My lord, here cognizance is understood. It's taken under section 419, 420, 272, 273, 269, 270, 34 IPC. Section 3 of Epidemic Act, section 20 of Tobacco Act, and also under section 103, 104 of Trademark Act.
Yes.
Now, all these offences which are alleged against me and cognizance is taken, all are not made out from the face of the FIR. Lordship, kindly talk.
Not FIR, charge sheet.
One application was disposed of before this in relation to this case and exactly this same issue.
But previously, I challenged the FIR before charge sheet. Honorable Court granted interim stay order. And stay order was communicated to the lower court and also to the prosecution. In spite of that, charge sheet is filed and cognizance is taken, my lord. And law is well set.
Eita kondu CRLMC 16250/2020. It
Where
was
is that order?
disposed of on 25/2023.
Where is that order?
That order, my lord, I have with me the interim order.
No. It was disposed of.
It was disposed of means, my lord, that was
after disposing of that matter only, the charge sheet might have been filed.
no, before that.
Let us see that order. All the order of interim order as well as final order.
Yes.
Dispose of order to the
What is it? There. 30? No, 33 is the interim order. Interim order. No, where is the final order?
That is the final order. It was dismissed for non-prosecution.
Where is the interim order?
Interim order was.
See, that's the problem. You get the interim order, don't go there.
No, Miller.
Because you are enjoying interim order. Why should you go to the court?
Interim order was passed on 31st/1/2022.
31st?
1/2022.
And charge sheet filed on?
Charge sheet filed, Miller.
charge sheet filed on 31st/7/2021.
Yes.
31st/7/2021.
Before that.
Page 22.
Miller.
Just see page 22.
21, Miller. But Lordship will
31st July 2021 is the date when charge sheet is filed. When you got the interim order?
Just before that, my Lordship, kindly turn to page 22. What my Lord Senior is.
I'm on 22 only.
But that is produced before the Lord Magistrate on 12/12/2022, Miller. That is there in the certified copy.
No, the charge sheet was.
They have prepared on that. Charge sheet they might have prepared.
No, then charge sheet is prepared. It is placed on record only. Charge sheet is prepared on 31st July 2021. Thereafter, you got an interim order. That will not help you. Tell me on merits if you have a case. Tell me on the merit you have a case. There are all these offences, and you want in the 482 court should examine each and every offence, whether it is made out or not. Cognizant stage, you can argue those things in the at the time of framing of charge. Why don't you do that? I'll give that liberty and go and argue. Because see, in cognizant stage, I can't examine each and every offence is made out or not. It is only the charge court to do it.
Observe
Counsel, by way of this petition, the petitioner has challenged the order dated 12/12/2022 passed by the JMFC Jajpur in town CT case number 1366 of 2022, whereby the court below has taken cognizance of offence under section so and so, so and so, so and so. Learned counsel for the petitioner submits that he would be arguing all these all the points he has taken in this petition at the time of framing of charges, and seeks to withdraw the present petition with the liberty as spread. The petition is accordingly disposed up disposed up with the liberty as spread. Argue all these points. Next.
50.
53.
53.
May I please, Lords? The petitioner challenged the order of a cognizance by the annexure 2.
Yes.
The FIR was lodged for commission of offences under section 498.
Where is the charge sheet?
Charge sheet was filed in the year 2000.
Where is the charge sheet?
Charge sheet copy again.
Copy of charge sheet. You have not filed charge sheet copy.
No, I have not filed charge sheet copy.
Cognizance order you are challenging. Charge sheet is not filed. Cognizance is taken on the charge sheet only.
My lord.
That is the basic. That is basic document. If you don't file, then how can I examine it? You file it urgent to enable the petitioner to file the copy of the charge sheet. Yes. Next. Next.
55. 54. 54.
Yes.
54, item 54. I am appearing for the opposite party. So except 254, except 294, all are compoundable and matter has already been settled. I am filing the affidavit.
They've settled.
I settled the dispute. I'm
I'm
sorry. My learned friend can have certain instruction or your lordship.
You are for the petitioner.
Yes, madam.
He is arguing for you. You are not saying it.
No, my lord.
Are you opposing that?
No, my lord. Both the matter is already amicably settled.
Settled. Where are they?
Yes, Asina, because some direction was not there. Because
What is the offense? Compoundable offense.
all are compoundable except 294.
294 chale also compatible.
What do you suggest? Shall I finish it up?
Submission of the both council will also be recommended.
They are not there, but
Because court only wants to.
bring them tomorrow online.
Online or physical? Day after tomorrow? Day after tomorrow?
Tomorrow.
Huh?
What? 2 o'clock.
Mala.
Bring 2 o'clock. Tomorrow, 2 o'clock. Okay. Bring them. Why unnecessary? Because the lawyer will be blamed sometime. You never know.
I'm filing it.
Oh, take on record. That's this one. And tomorrow, 2 o'clock.
My lord.
Yes. 55. Aadhaar card also you get it.
Aadhaar card copy I have.
Yes. Perfect. Yes.
55.
Yes. Pass over.
56. May I please, Your Lordship, my lord. This is Belgium matter, my lord.
Are you on bail?
Yes, my lord.
When bail?
Bail was granted by this honorable court on 8/8/2018, my lord.
8/8/2018.
And
Bail.
NBW was issued on.
Okay. He will appear on or before 25th of this month. NBW?
21/6/22. But it
21?
is.
No.
It is wrongly typed, my lord, because
9/10/2020.
earlier issued on 21/6, it is written not executed yet.
The order, the NBW order is
21/6/22, my lord.
21/6/2022.
Yes.
2022.
Yes, my lord.
1,000.
That is upper part, my lord. That order's upper part is there. Yes.
Only 1,000.
That order?
9/10 order, the upper is that NBW order is there.
That I know that. The initially the 21/6/2022. Page 12. No? Page 12, the order. Okay, 1,000.
Obliged, man.
Yes.
57.
Beg pardon, my lord. I skipped in the item 55, my lord.
Sorry?
Item 55, your lordship. I skipped from.
Passed over at 2 o'clock. You can't jump anytime.
No, my lord. Actually, I connected.
No. Maintain some discipline. No, 2 o'clock. Passed over means 2 o'clock.
Lordship, in item 57, I'm praying for an adjournment.
Urgent.
Obliged.
Yes.
58. It's a peculiar case before this honorable court. 133 order was against 133 order. 397 revision was preferred. My prayer before the HDM was that to remove that gas pipe which was erected from latrine tank. The HDM on the basis of the sanitary inspector's report dismissed my case. I preferred a revision before the learned ADJ. The learned ADJ, my lord, allowed my prayer and set aside the said order. However, he stated that to increase the height of that pipe, my lord. Against that, partly agree. Since I am partly aggrieved by the order of the revisional court, this 482 has been preferred, my lord.
Mr. Maharaj, is it
Private
maintainable?
Yes, my lord. Maintainable, my lord.
Which is the order you are talking about?
Order, my lord, is
which page?
Annexure 4, page 20.
Okay. Against the revision order, huh?
Yes, my lord.
Revision order?
Maintainable, my lord.
Yes. Yes. You are agreed by what? Which part?
Annexure, my lord. Poor lordship may see the order portion, page 26.
Yes.
The revision petition filed by the petitioner is allowed against the opposite party on contest without any cost, and the order passed by the learned HDM Baripada is set aside, and the opposite parties are directed to increase the height of the gas pipe of the latrine tank up to a height of at least 5 feet from the present pipe height. I am aggrieved by this order.
Why?
Because, my lord, I have a 2-storied building, my lord. Now, if this order sustains and they increase that pipe up to 5 feet, my lord, it will be very difficult on my part to reside on that side, my lord. 133 order is mainly on the basis that to avoid the nuisance, my lord. Now, it's a, my lord.
This order is passed on the initial order of the SDM. Where is that order? SDM order.
First order, sir.
Annexure 3.
My lord, Annexure 3.
Just see Annexure 3. Whatever. 133.
My
What is
lord.
the scope of 133?
133 is with regard to conditional order for removal of nuisance.
That 133.
133.
133. Read it.
Well,
Whether it does it come under the scope of this order? Increase of the length of the pipe and all. Yes.
my lord, 133C, my lord, that the construction of any building or the disposal of any substance as is likely to occasion conflagration or
explosion should be prevented or stopped, or that any building, tent or structure or any tree in such a condition that it is likely to fall and thereby cause injury to the person living and carrying the business and removal, repair or support of such building, tent, structure and removal and support of such tree and necessary. That any tank, well, and excavation adjacent to any such way at public places. Dangerous. It can be only removed, but it can't be constructed.
Well,
that is what your case is.
Because moreover, my lord, in their show cause they have stated that they have agreed to remove that said pipe up to 4 to 5 feet, my lord. Lordship may come to
you are
page 16. First party, my lord.
You are the Gajendra
Kapat.
You move the application.
My lord. As first party, my lord.
You move the application against the opposite parties.
My lord.
Under section 133.
My lord.
And you got this order.
My 133 was dismissed.
Then you went to the
Revisional court, my lord.
And revisional court has passed order against you only.
No, it has passed in favor of me.
But that observation is against you.
Against me.
Look, the petitioner had moved an application under section 133 CRPC. CRPC against the opposite parties. Oh, number 2. Opposite parties, na? Against the opposite parties.
My lord.
Against the opposite party. The said applications were turned down by the learned SDM. By its order dated 26/5/2023. The petitioner moved the revisional court. While disposing of the criminal revision 25 of 2023, the learned court of AD, additional district session judge Baripada passed the following order, page 26. Following order. The petitioner, the counsel for the petitioner submits that he is aggrieved by the part of the order by which the revisional court has directed him to increase the height of the gas pipe of their latrine tank up to at least 5 feet from the present pipe height. He seeks indulgence of this court. Issue notice to the opposite party. Parties, returnable within 2 weeks. Okay. Issue notice.
59.
Date, give a date, March.
May I please?
Yes.
Arising out of section
59.
Yes.
Arising out of section 133 CRPC proceeding.
Yes.
The opposite party number 2 before your lordship was the applicant of first party in the 133 proceeding, and the present petitioners, they were the opposite parties. Dispute regarding an old palm tree which was in bending position upon the courtyard of the applicant, my lords. Now, my lord, your lordship may kindly take note of a date. The 133 proceeding was filed on 26th of April 2016.
Yes.
Thereafter, on the same date, on 26/4/2016 and 14/12/2016, a direction was, an order was passed by the subdivisional magistrate directing the IAC as well as the Tahsildar concerned to cause inquiry and submit a report. Now, on 17/2/2018, the final order was passed relying upon a report dated 2nd of April 2016. I have annexed the copy of that report.
Right,
Your Lordship, I'll take your Lordships to page 22. Your Lordship may kindly come to page 22.
Annexure 4. Yes.
Annexure 4.
Yes.
Bottom, Your Lordship. It begins, the Tahsildar Raghunathpur has submitted the inquiry report vide is letter number 31 dated 2/4/2016, which was conducted by the
Page 23.
page 22, annexure 4, Your Lordships.
Yes.
That is the order
Submitted
dated
inquiry report by letter dated shown 2/4/2016.
2/4/2016, which was conducted by the RI Chapada. In this report, the RI has submitted that one palm tree and one bamboo tree of opposite parties are existing near to the building of the petitioner. On perusal of the report, it is ascertained that there is every possibility to fall down the tree in any time over the house and courtyard of the petitioner and damage the building of the petitioner and endangerous to human life and property. This order was passed. I have also annexed the copy of this order, this report, that is at page 18.
All right. Thereafter, he has gone to revision court.
Thereafter, we approached the revisional court.
Why this order was there?
This order was set aside. I am placing the facts. Some facts are relevant because there are two rounds. This order was challenged on the ground of non-compliance of section 138 of CRPC. And on that, or due to non-compliance of section 138 CRPC, the revisional court set aside the order 17/2/2018 and remanded back for fresh adjudication. Thereafter, another order was passed, that is at annexure 7, page 29, 16/4/2021. 16/4/2021
yes.
at page 29. And again, I challenging that said order, I approached the revisional court. The revisional court confirmed. Now, thereafter, I am before your Lordships in this 482 application. My first ground of challenge is that prior to, in spite of two directions of the SDM, directing the IAC and the Tahsildar to cause inquiry and submit report in accordance with section 139 of CRPC.
Yeah, there is a report already.
No, my lord. That report was prior to initiation of the proceeding. And post initiation of the proceeding, two directions were passed.
But there is a report already.
Report, my lord.
The trees.
This amounts to non-compliance of section.
There and that report is already there.
139 CRPC mandates that there must be a local investigation and a report must be submitted. So, your Lordship may kindly see this annexure, this impugned orders which were passed, annexure 3 series. These were never complied. And 139 CRPC, your Lordship may kindly come to section 139 CRPC.
So, what is your grievance left now?
My grievance is, my lord, there is no inquiry, non-compliance of section 139 CRPC.
That is technically you may be correct, but
there is
around what you want.
My lord, this order has to go due to non-compliance of this 139 CRPC.
Around what you want. It will go or it will stay. That's a different story. What
So
exactly you want from this dispute?
I could not follow, my lord.
What exactly in the ground you want? What is the ultimate relief you want?
Relief, my lords, I am praying for setting aside this order because this will not, and 133 will not be attracted even also on merit also.
Are you disputing that the tree is not bent?
No, likely to fall. Report, your Lordship may kindly see. I have also annexed
the idea of 133 and all is only to see in the ground that some nuisance should take place. Don't argue on technicality.
Again,
what exactly you want tell me?
Inquiry again, jota he habba kotha.
Subudha chhadi diyantu. Mote kon darkar apnu. Petition chhadi diyantu. Kon darkar apnu.
ताले से आसे की सेटलमेंट करंतु जदी हमर एक्चुअली बाउंगाटा तांकर एक्चुअली पाचिर को ढोली के रही छि
काढ देबे काम खत्म ए 133 144 ये सब जा पढेबार करे गछर जदी बैंड हे जी
खाली गोटे
सरला काम
सेटा गोटे
एस्पेक्ट पिटिशन बनैलेनी
खाली गोटे
submitted by the petitioner.
नहीं आगे I have not completed. खाली गोटे फॉर
काढ देबे you will remove the tree.
नहीं मु गच्छ काटिया तांको गच्छ से पर्यंत जाउनी କୋଟିଆଟା ମାନେ ବିଲ୍ଡିଂ ପଛରେ 25 ଫୁଟ 30 ଫୁଟ ପଛରେ ସେ ନିଜେ ବି ଆଡମିଟ କରିଛନ୍ତି ଆଜ୍ଞା ସାଇକ୍ଲୋନ ରେ ଯାଇନି କି କୋଉଥିରେ ଯାଇନି ଲର୍ଡସିପ ମେ କାଇଣ୍ଡଲି ଖାଲି ତାଙ୍କ ଡିପୋଜିସନ
dragging the proceedings on technicality.
ଖାଲି
Tell me
ବିଶ୍ୱଜିତ
in the ground what to do. Finish up. Technically, you may have a fantastic case, but ultimately it is arising out of 133 proceedings. 4 rounds of litigation because one tree is bending towards his courtyard. That is the whole dispute.
that is the whole
Come to
dispute.
that. Forget about this.
Then I'll take instructions, my lord. I'll ask the client to
Remove that
settle.
tree and finish and all these petitions are everything is stopped.
So actually ତାଙ୍କର
Substantive thing.
ନାଇଁ
Technically this happened, that happened. Why unnecessary? 3 rounds, 4
ଖାଲି
rounds.
ଖାଲି ଦିଟା sentence from the deposition, my lord. 2 statements.
I will not read you. Will you remove it?
ତାହେଲେ ମୁଁ
Remove that tree. Cut it.
ସେ ତାହେଲେ ସେଇ ଯେତିକି ତାଙ୍କ ଢାଳ ମାନେ ଯୋଉ ବ୍ରାଞ୍ଚ ଟା ଇଏ ହେଇଥିବ ସେଟା କାଟିବା ପାଇଁ କହିଦେବି ଆଉ
କାଟିକି ଖତମ
ମୁଁ ତ ସେୟା କହିଥିଲି ସେ ବ୍ରାଞ୍ଚ ଟା କାଟିଦେବା ପାଇଁ ଯୋଉଟା ତାଙ୍କ ପାଚିରିକୁ କ୍ରସ୍ କରୁଛି ତାହେଲେ ଗୋଟେ ବି ଟାଇମ ଦିଅନ୍ତୁ
on 12th remove that tree finish. He is happy, you are happy.
ତାହେଲେ ଏଇ ଲର୍ଡସିପ ମେ ଗ୍ରାଣ୍ଟ ମି ଟାଇମ ଆସୁ 12 ତାରିଖ ଆସୁ
12th. Remove it. You may have a fantastic case on merit in the sense technically, but the fact remains that this one tree is so much a problem.
The date I
judicial time is wasted, your time is wasted.
No, my lord, the date I took up this matter, I also because they have some
advise them to remove it. Finish. Advise them to partly remove it so
ସେତିକି ପାଚିରି ସେପଟୁ ଯୋଉଟା ଥିବ କାଟିଦେବେ
କାଟିଦେଲେ ସରିଲା କାମ
ଯୋଉଟା କାଟିଦେଲେ ସରିଲା
ଆକୁ ଏପଟେ ସେପଟେ କାହିଁ 4 ରାଉଣ୍ଡ ହେଇଗଲାଣି ଆପଣଙ୍କର
ଆଉ ଆପଣ କମ୍ପ୍ଲେନ କରିଲେନି
interim order to
come with instruction.
Interim order to continue till 12.
Interim order will continue. No problem.
ଅଛି
ଆପଣ ଏମିତି ଲଢୁଥିବେ ସେ ଗଛ ହିଁ
ଅଛି ଆଜ୍ଞା
No interim there mila.
ଆଜ୍ଞା ଅଛି
ଥିବ ବୋଲେ
Your lordship may kindly see the order dated 6/1/2023. That was the original order. Interim order was passed.
interim order.
Yes, my lords. That has been continued.
আমি লড়ুଥିବେ ସେ ଗଛ
ନା ସେ ମିଛ କଥା ଲେଖିଛନ୍ତି ଯେ ସାଇକ୍ଲୋନ
ନ୍ୟାଚୁରାଲି ସେ ଗଛଟା ଭାଙ୍ଗିଯିବ କେତେବେଳେ ତାପରେ ଆମେ ଲଢୁଥିବେ
ଗଛ already
spending much more than the branches.
Report is there. They have admitted that.
ନାଇଁ କିଛି admit କର କିଛି
remove it.
ନଡିଆ ଗଛ ନା
On 12th, the part of the tree which is leaning towards their courtyard,
palm tree.
part of the tree which is leaning towards their courtyard, remove that.
ସେତିକି କାଟିଦେବା ପାଇଁ
And everything is over. And you should also be satisfied.
Obliged.
60.
Shall I record it?
No, my lords. Your lordship may not record because your lordship may kindly.
I'll record it so that
ନାଇଁ ଆସୁ 12 ତାରିଖ ଦିନ 12 ତାରିଖ ଦିନ ଆସୁ I will take up the matter with the client.
ସେ ରେକର୍ଡ କରିଦେଲେ ସେ ବି ଇସ୍ୟୁ କରିବେ ଏଇଟାକୁ ସେ ଇସ୍ୟୁ କରିବେ ତେଣୁ ଆମର ଥାଉ ସେ ଆସନ୍ତୁ
ଓପେନ ଥାଉ
ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇକି ଆସ
Obliged.
ଜିଦି ଚାଲିଛି
ଓ ଦିଦି ଆଉ କିଛି
ପୁଣି ଗୋଟେ ଚାଲିବ ସେଗୁଡ଼ା ଦରକାର ନାହିଁ ଖାଲି ଜଷ୍ଟ ସେଟଲ
only that part, the part which is leaning towards their courtyard, just remove that, and the remaining part let it be like that. Okay. Yes.
Item number 60, both parties are present. The matter already settled.
Acha. What is the term of settlement?
Mutual divorce already
Dakontu.
drawn.
Dakontu. Vishwanath Tripathi. ଆପଣ ବିଶ୍ୱନାଥ ତ୍ରିପାଠୀ ଆଚ୍ଛା ଆଉ ବାକି all mother and sister-in-law
Mother, sister and
and
brother.
ସଙ୍ଗୀତା ଆଚାର୍ଯ୍ୟ ଆପଣ ସେଟଲ ହେଇଗଲା ଆପଣଙ୍କର କଣ ସେଟଲ ହେଲା କଣ କଣ ଡିଭୋର୍ସ ସରିଲାଣି ଏଲିମନି ମିଳିଗଲା ଦରକାର
No.
By way of the present petition and the petitioners have invoked the inherent jurisdiction of the court under 482 CRPCs, interimly are seeking washing up to the criminal proceeding of Mahila PS case number 14 of 2020 corresponding to GR case number 7, page 5. The parties are present in person, represented by their respective counsel. they are identified by their respective counsel. They have filed the photocopy of the Aadhaar card, party name. Petitioner number 1 and opposite party number 2 are present in court. Okay. Take it. On query from the court, the opposite party number 2 submits that she has settled the dispute with the petitioner number 1 and her in-laws. Pursuant to their settlement, they have applied for divorce by mutual consent, and by order dated 22/2/2023, the family court Cuttack has allowed the application and granted divorce by mutual consent. She states that she has also filed an affidavit dated 12/7/2023 inter alia, stating that she has settled the dispute with the with the petitioner number 1 and his family members. Petitioner number 1, they have acted upon the settlement terms and obtained the divorce by mutual consent. She doesn't want to proceed with the present case. Hence, she prays that the criminal prosecution initiated by her against the petitioners may be quashed. Mr. Maharaj appears for Mr. Ragana appears for the state and submits that since essentially the dispute is rising out of a matrimonial discord and the parties have now settled and decided to part away, no legal impediment. There is no legal impediment for quashing the present FIR. Taking into consideration the fact which submission in the bar, the FIR number so and so and consequential proceedings thereof. Quashed. Yes. Quashed. Come on. Huh? There are 2 matters finished up. Password, but we'll take it up. These 2 matters. That is 61.
I'm for the opposite part number 3 in the bank.
Opposite party number
3.
Okay.
May I play it? In this case, my lord, the petitioner challenges the order dated at 10/4/2023 passed by the London Sessions Judge Baleswar, my lord, in reversing the order under Annex 3 passed by the London STJ.
Who is appearing for the opposite party number 2?
Private doctor.
You are for the bank. You are for the bank. You are for the petitioner.
I am for the petitioner.
What is this case?
My lord, I have a hypothetical vehicle. During running the vehicle, my lord, due to some money, my lord, wanting of money, I have got a hand loan from the opposite number 2. Thereafter, I have refunded the money. At the time of receiving the loan, my lord, from the opposite party number 2, I put some signature in the blank papers, my lord, for reliance. But thereafter, my lord, the opposite party number 2 made an agreement in that blank paper. Basing upon that agreement, he claimed that my vehicle is mine.
What is the role of bank?
Because, my lord, during hypothecation from the bank, my lord, the third party interest cannot be created as per the agreement. But here in this case, what is happening, my lord?
You have created third party. Why have you signed the blank papers?
I have taken some loan from the opposite party number 2. For keeping reliance, my lord, I have put some signature, my lord. But the basing upon thereafter, my lord, while the vehicle was plying on the road, my lord, due to some defect, machinery defect, with intimation to the police under Annex 3, my lord. With the intimation to the police, I have the goods which was transported from Chennai to Calcutta I have shifted in another vehicle and the vehicle was with me. Thereafter, all in a sudden, the police on 17/12/2022, my lord, seized my vehicle. Thereafter, I filed a petition under section 457 of CRPC before the London STM. Thereafter, on basis of this agreement, my lord, the opposite party number 2 on 27/12 lodged an FIR. Thereafter, he also filed a petition before the London STM for releasing the vehicle, my lord.
457.
Yes, but then the London STM, after hearing the parties, allowed me to release the vehicle in my favor. Challenging this same, my lord, the opposite party number 2 filed a revision before the London Sessions, and the London Sessions was, my lord, reversing the order. This is the fact. Yes,
Who
ma'am.
is the owner?
I am the owner, ma'am.
But there are papers.
In RC book,
You
they
have
are the
signed the
owner.
papers.
Yes, my lord, but
Wrong or right, that will be tested. But as of today, the papers are in his favor. You have already sold.
but during hypothecation, no third party interest cannot be created, my lord.
But you
As per the
created
agreement,
for
my-
that case is going on.
my lord.
For that the purpose, there is a case which is registered against you. You have wrongly violated the conditions of hypothecation by executing documents in favor.
Whatever loan amount I have taken from the opposite party number 2, I have already refunded the amount to him. Right? When I call him,
Where is the opposite party number 2 then? Notice was issued sufficient?
They were appearing on every date. I don't know when.
Pass it over, let us see. Let him come. In his absence, nothing can be done. What bank will do?
let it
Bank
come
has
next
no
week,
role
my
to
lord.
play, basically.
Let it come next
It's
week,
a
my-
457 application.
In fact, they are.
Whether it should be allowed in your favor or his favor, that is to be decided.
Yes, ma'am. Yes, ma'am.
Who is the owner? That's the whole question. It has to be released. But he says that it is I am the original owner.
But the loan amount
Number
is
2
20
is also
lakhs.
saying that I am original.
My lord, the loan amount is 20 lakhs, my lord. I have only taken him from him, my lord, only 2 lakhs, my lord.
So you have a better superior claim because you have taken the loan from the bank. That's
Yes,
what
ma'am.
you say.
Yes, ma'am. Let it come next week, my lord.
Why next week? After lunch, if they come, we will do it.
Obviously.
Well, in fact, I have got one more matter there in after lunch.
The whole after lunch, we will do that matter.
Well, that will be coming around 2:30.
Okay, urgent to next week sometime.
Interim order.
Interim order to continue. What is the interim order in this case?
Stay operation of the revisional order.
Not to release
Yes.
him. Not to, okay. Okay. 62. Yes.
Your Lordship, I am for the petition. In this case, I have challenged the praying for passing of the cognizance order taken by the Lord JMF C1 Bhadrak.
Yes.
In GR case number.
Okay. So you.
In this case, my lord, my humble submission is that my wife has filed 2 proceedings against me under IPC. First, my lord, may kindly peruse. In appendix, I have stated 13/7/2017 ମୁଁ ଗୋଟେ ଫାଇଲ କଲି restitution proceedings 13/7 ପରେ 1/11/2017 ସେ ଗୋଟେ ମୋ against 1cc case କଲା under section 498 and other offenses ସେ case ଟା decide ହେଲା ମିଲଟ 4/11/2022 immediately 4/11 ପରେ ପୁଣି 24/11 ସେ ମୋ ନାଁରେ ଗୋଟେ FIR ଦେଲେ same offense 498 341 to 323. So I am praying for passing of the cognizance order as well as the FIR.
I will not pass any interim order, but I will issue notice and call her.
Milord, notice has been issued. The notice has sufficient against the opposite party, and Milord, interim order.
A report was called for, and Lordship may
Status quo report.
Flag A.
Flag A. What is this? Flag A.
Status report of 1cc case number 4180.
Yes. Totally, I am going to submit here the status report. So the case report was instituted on the same day. The case was sent to TLSA, but the original complaint petition along with the copy of what form to pass by the committee. When the committee was told for distribution, here was reference for CIC. Or the now the case 19/2/2024, matter is pending.
My lord,
February.
once you say, my lord, I will be highly prejudiced. Already I am facing a trial under section 498. Thereafter, filing another case, I'll definitely not only malign my reputation in the society, but also a kind of res judicata also applied in that case.
No, that's there, but the matter is on.
Rest of judice.
On matter is posted on 19/2/2024. Before court below. Go and argue all this point. I'll keep it pending.
My lord, but I am praying for passing of the FIR.
That's right. You
That
say
is
that this
recently.
is not maintainable. The one ICC case is not maintainable in view of the FIR. You argue all this point. I'll keep it pending. I'll record your statement.
My lord, I am already facing trial in 1CC case.
That's right. You argue that you have an opportunity. You argue and see, pursuant to the order dated, look, pursuant to the order dated 8/1/2024, the court of JMFC 1 cognizance taking Bhadrak plug has submitted a report dated 27/1/2024 inter alia informing this court that the 1CC case number 4184 of 2017 is posted for hearing on 9/2/2024. 9/2/2024. Then counsel for the petitioner submits that the 1CC case registered against him is a proceeding which indeed is not maintainable in view of the earlier FIR registered against his clients.
Pardon me, Lord. I am praying to let the 1CC continue and because the on fresh allegations 498 says instituted. So the recent one may kindly.
Submit that. On CC case registered in the face of the 1CC case registered against him. Registered against him, the subsequent FIR registered on the self-same allegations is liable to be quashed. Liable to be quashed. Therefore, he seeks indulgence of this court. Since the matter is now listed before the court below, the 1CC case is listed before court below on 9/2/2024. The petitioner seeks liberty to 1CC case. Either of this one case will go on.
My lord, I am ready to face trial because ମୁଁ ସେଇଟାରେ ବହୁତ ସମୟ ଦେଲେଣି already.
1CC
ଟାରେ ଏଇଟା she has just amended her things and made this FIR which is not applicable. ତ ମୁଁ ଭାବୁଛି ଯଦି ଏଇ 490 ଟା ପାସ୍ ହେଇଯିବ
ଖାଲି ସେତିକି ଲେଖିଦିଅନ୍ତୁ since is listed on lease this matter immediately after 19 ଅଛି ନା on 21st नहीं 19 ଅଛି 19 ନା ହଁ 21st February. Let us see 21st February interim order to continue.
My lord, not pass, my lord. Interim order pass ହେଇନି. There was no interim.
महाराज କୁହନ୍ତୁ କଣ interim order ଆଇରେ
The stay of further proceedings so far the 1CC case is concerned in which the second
My lord,
no 1CC case he wants to continue 498 charge sheet has been filed. Cognizance has been taken.
My lord, cognizance.
charge sheet filed cognizance taken.
Just stay रहो
Till then
matrimonial dispute unnecessary ଗୋଟେ case ପରେ ଗୋଟେ case ଗୋଟେ ପରେ
like anything.
Actually very unfortunate. Matrimonial dispute ରେ
student ମାନଙ୍କ ପାଖରେ school ରେ ଯାଇକରି botheration ହଉଛି. I am harassed like anything. I am a teacher.
Last may stay that.
Proceeding before ये जो IA कोटा election थे अपना. Why don't you settle and finish up?
My lord, already she is not willing to.
देखो the further proceeding where is your application further?
Sita kain?
He doesn't have application.
1CC last time.
Where is your IA?
He is not available.
You don't move application here.
No, no,
You don't have application. You move application. Where is the application?
In this case, one day.
No, he has not moved.
The magistrate malad should have called for the report. When the matter came to knowledge of the court below malad, who is presiding the over the matter malad, he has to call for a report from the police to under 210 of CRPC. And both cases,
In any case, see, I am putting it on 25. You have not moved an application.
ସେଇଟା argument
Please.
ହେଇଯିବ।
ହଁ, ଆପଣ କରନ୍ତୁ ସେଟା, and he is rightly advising you. And since in the absence of any application, I can't pass the order.
And the subsequent master will not proceed with the 1/6 malad.
Yes.
Since that is pending with the police. That is the law malad.
Okay. 21st. 21st. The over. Board is adjusted. Only pass over.
Pass over.
Pass over. Adjourn.
Item 8.
Nobody is there.
Item 9.
What is happening here? What do you know?
Item 12.
May I please, my lords?
Hmm.
I seek for an adjournment for 2 weeks, my lord.
Why?
My lord, because today the file is not with me, so my lord.
Compromise matter, my lord.
Compromise matter, your lordship may keep it to 28th, my lord. The matter would be settlement, because my lord, the parties are not here. Any order may be passed for the parties to be here. On
You have settled, then you bring them when
my lord, 20th.
20th.
Obliged, my lord.
Or if you can bring them
Through
online
virtual mode.
also, we'll
My lord. Obliged.
Yes.
This is a case wherein my petition under section 227 to discharge has been rejected.
Okay.
And there is a the sections under which the charge sheet was submitted includes section 124A. Now, by order of the Honorable Supreme Court, all over the trials and so has to be stayed, because that is pending now, presently pending before a constitutional bench. And prior to that, it was before a 3-judge bench of the Supreme Court. And they said that this provision was enacted prior to the independence of the country. It has no relevance. On that debate, they have stayed all the proceedings. So, without going into the...
Where is the charge order? Where is
that
the
I have. This is the time.
No, the charge order, which you are getting.
Charge has not been done. Before charge...
Charge has been framed. That's what you say.
Not framed. Before framing of charge, I have filed the petition under section 227. But thereafter, under 228, charge is to be framed.
227 is rejected.
Has been rejected.
Then formal charge has to be framed.
Formal charge.
Where is 227 rejection?
Annexure 1 at page. And prior to that, I have approached this Honorable Court. This Honorable Court with categorical observation that the grounds taken in the criminal miscase, like prior sanction is required for the UPA, Unlawful Activity Prevention Act, that is prior sanction is required. Now, the Bambedkar decision, Supreme Court state, those things had to be taken into account. Now, the rejection order here does nothing and merely rejected.
Let us see.
That's Annexure 1.
16, 17, 18, 20, 23,
Yes.
and 38 of
the unlawful
activity.
And 124A of IPC. Here, may I read the impugned order. Accused Sangram Kesari Mahanti is absent and allowed to...
Relevant part you read. Peruse the record, Parate. Peruse the record.
In the present case, charge sheet under section 177
it has been submitted against
the
person from the
17
charge sheet
has been submitted against the said applicant from the materials available in record in FIR. Charge sheet statement of the witnesses recorded under section 161 CRPC and other connected papers available in the case record clearly show the complicity of the accused person.
No, it says that it has already highlighted the CBI versus Hyderabad versus.
They say at this stage, court need not go into a roving inquiry. But this is not a roving inquiry. When law doesn't permit prima facie on this face of it, there is no question of going into any roving inquiry. So and so report jurisdiction that so and so the should not make a roving inquiry into the pros and cons of the matter.
Yes, which judgment you want to show me?
Yes. 11.5, the relevant
para
the para minus paragraph D. The last page of the judgment or statement. They finally observe these steps has to be taken. They say all pending trials, appeals, and proceedings with respect to the charge framed under section 124A by IPC kept in abeyance. Adjudication with respect to other sections, if any, could proceed if the courts are of the opinion that no prejudice would be caused to the accused.
Only 124A you are
124A. Now 24A, but here serious prejudice would happen because this is a case after 11 years. Now they are putting the matter for charge, framing of charge. In the meantime, I was in jail. They did not produce me in time. I could not face the trial. Co-accused person, all the co-accused persons have been released have been acquitted by the trial court. It's not my fault. 124. And these, besides this, the other point was raised. The section under the Unlawful Activity Prevention Act requires valid prior sanction, and that too within the stipulated time as per the rules. And in this regard, another judgment was made by this Hon'Ble Court while quashing the cognizance law, saying that how it is very much required that the cognizance should be taken with prior sanction within the time period. These things have not been examined, merely rejected.
Sedition law is already now suffer an amendment. New act.
And the last thing that has not been raised, but as I find, the court lacks the jurisdiction to decide the matter. The additional session judge doesn't have the jurisdiction since UPA Act comes under the NIA Act, National Investigation Agency Act. Under that, it is a scheduled offense under the UPA Act, and the special court has only the jurisdiction to decide the matter. Here, the additional session judge doesn't have the power of a special court. Special court either to be appointed by the
For
center,
taking cognizance or for trial?
for trial, for taking cognizance also it cannot take.
So me,
Only taking cognizance.
so me,
Section 22, Lordship may see section
22 of who?
22 of
Unlawful, unlawful.
National Investigation Agency Act.
No, you read it out. NIA Act, na?
Yes,
read it.
se kouchan schedule offense guda gote dei dele. Ta bitre unlawful
Read.
22 power of state government to constitute special courts.
Right.
The state government may constitute one or more special courts for the trial of offences under any or all the enactments specified in the schedule. The provisions of this chapter shall apply to the special courts constituted by the state government under subsection 1 and shall have effect subject to the following modifications, 90 so and so all these things. 3. The jurisdiction conferred by the Act on a special court shall, until a special court is constituted by the state government under subsection 1 of the case of the offence punishable under the Act, notwithstanding anything contained in the code, be exercised by the Court of Sessions of the division in which such offence has been committed. So, and relying on that,
But there is no bar. There is a bar. They said there is no bar.
No,
There is no bar. It is a
it
schedule
is
offense.
only the Supreme.
It is a schedule offense under the.
Yes. Then the
NIA.
special court.
There is no bar. Court can take.
Bar code is,
If-
and
if
Indian
there
Penal
is
Code
no-
is also there.
They will designate the special court. If the special court
Yes.
is not designated, there is no bar.
Then the sessions court. Then the sessions court.
Then the session.
So sessions code.
Here it is the additional session court, is not the sessions court.
No. Additional special court and say
Not
power
the
is
sessions
same.
court. That has
Power.
been clarified by the Honorable Supreme Court in another judgment. I'll give and
Show me.
I also mean. Also in another.
Additional session judge and session judge are same.
Not a way.
Same.
It say that.
Power is same.
Yes, my lord. They have defined, clarifying that since it has.
Where is that you?
I'll supply the
I'll
judgment.
just simply then I'll adjourn it only. If you don't satisfy me,
No.
I can take the aid of this. Only 124A I can very well stay.
Yes.
But the other offences will go on.
No, 124A subject to the proceedings can be stayed if it causes prejudice to the accused. Once I face the trial for other offences, and later on, then I have to face again.
That is
trial
not
for
the prejudice. That is not the prejudice. That is not the prejudice. All the cases this will happen then.
But it never happens, my lord, for one offence.
That is what the order has been passed by the Honorable Supreme Court.
Honorable
It says that-
Supreme Court has stated that
the other offences will go on.
124A will.
124 will stay.
But the
Can
next
happen,
line,
sir,
lordship
other
may see.
I know that will
Yes,
not.
they say that unless it causes prejudice to the accused, the court has the power to stay the proceeding. That is what I say. I say once he has faced the trial, he go through the rigorous process of trial. In the next day, suppose claims 124 comes to be valid, my lord.
What do you
Then
say?
yes.
Why can't you quash that 124?
124A is kept in abeyance by Honorable Supreme Court. Unless until a final order is passed, we cannot, my lord,
That's
rule over the same act.
If from the record, if I find
Yes.
there is no 124 is made out, I'll quash it.
You'll also make quash it that. Let it go. But so far the other offences are
Oh, that
concerned.
will remain.
So that will go.
That's what I'm saying.
That will continue.
124 I'm quashing. If it's the other matter.
Sir, 124 tax Supreme Court କହୁଛନ୍ତି ପରା ଯେ ଏଗୁଡ଼ା stay ହବ.
I will quash it. Where is the question of stay?
And others also, EPA.
No, others I will not
Other, without prior sanction.
124 capital A I am quashing and
But-
face the other offense.
No, my lord.
And take whatever.
Without prior sanction, as required under
Those
the.
things you argue.
No, that is there. Lordship may see
That has
the
not
order
been taken
passed by
into-
this Honorable Court Annex 2. Lordship may see what order has been passed. Because these things were raised before the Honorable High Court, it remanded the matter, giving a chance to raise such questions before the court. Necessarily means the court has to consider. Has it considered, my lord, in absence of any findings on the observations made by the Honorable Court, such a order cannot pass, my lord. That's my humble submission. He
Is
can
there any
proceed.
observation or any argument made before the trial court regarding sanction and any other things?
Yes, yes. Have you gone through my
Yes.
petition? I have
See,
filed, I have annexed.
This is the order.
No. Your lordship may see my petition, not the order. Petition has specifically stated about
No,
the.
just see, read page, come to page 20. Page 50. You read that. In terms of order dated 11 May 2022, the Supreme Court of India
Again.
so all proceedings under 122 have been asked to be kept in abeyance. Okay?
Yes.
And it is open to the petitioner to bring to the notice of the trial court the above order of the Supreme Court. We seen that there is an issue raised with the petitioner regarding the absence of a prior sanction for initiation of prosecution. Rather, the point is also left to be heard in the appropriate authority. The notice on 124, your argument in the earlier round is only revolving around 120. 124.
No,
Sanction is not required anyway.
Prior sanction is mentioned in this order.
Sanction insofar as 124 is A concerned. That is what you are arguing.
Sanction under the IPA.
Where is that? You there is nothing.
That was there in the read.
There is
Here
notice
also.
under no, just
The
look.
lordship may say
This
appropriate.
point is also left to the urge in the appropriate state, and notice under circumstances is only in respect of which the cognizance has been taken against the petitioner. See, provisions in respect of which the cognizance has been taken against the petitioner by the trial court, and it will open to the trial court therefore to pass an appropriate order in accordance with law, keeping in view all the above circumstances. No further order is called for.
And that is, even though, my lord, even though I have not raised, it's a, they are available, it's a mandate of law. Now, it has to be, the court has to see whether prior sanction is taken or not. And unless prior sanction is taken, how can it proceed?
Where
That
is the
is-
sanction? Where is the sanction provision?
Sanction provision 45 of the Unlawful Activities Act.
Sanction they can get post facto also.
Post sanction, no, this is not allowed, my lord.
While taking cognizance.
Yes.
No court shall take cognizance without.
Yes,
That is what the
prior.
language is.
That's
That's the language.
Now
That is
charge
the-
has
yes,
already
my
been
lord,
filed.
right. That is the language.
Look,
45, section 40.
40. What are the sections, chapter, which chapter?
ଗୋଟେ 196 ପାଇଁ IPC ର 197 IPC ପାଇଁ not under the fact.
Chapter 3. All the offences are chapter four,
basic.
chapter four offences.
Yes, 4 and 6.
No, chapter 4 offences.
38 ବୋଧେ ସାର୍
38, 1, 38. 4 and,
ଏଇଟା ବୋଧେ ପଳେଇବ
4 and
chapter 6.
chapter 4 and 5. Offences chapter 4 and
Chapter 4 and
5. 4 and 5. Let us see 4 and 5. Under
the
chapter
sanction ନେଇଥିଲା, this honorable court has already
and 6.
was the cognizance and
Without the previous sanction of the central government, or as the case may be, the state government If such offence is committed against the government of a foreign country without violation of- See, it will not help you. 45.2 says, just read 45.2, sanction is not required.
It's required. This is the judgment. They say.
Forget, I'm reading this. It says, let's see. It says, under chapter 4 and 6,
Yes.
38 is in 5.
Maybe.
But
For
38 is
38
5,
may not
forget.
be. Yes.
All other offences are 4.
4.
Without the previous sanction of the central government
Or
as the case may be, the state government.
Yes.
And if such offences is committed against the government of a foreign country without previous sanction.
So that's not applicable to us.
So sanction is not required.
No, that is not applicable. The foreign country is not applicable here in my case.
That is why I'm saying offences are, see, 4 and 5.
Yes.
If it is against foreign country, then only sanction is required. Otherwise, no.
No, not that. This is the interpretation made by the Hon'Ble Court and was the order of cognizance because no sanction was there.
No, sanction is required. If sanction is not
No,
taken,
that is not there.
everything vitiates and I want. Where is that? Offences.
They say how and why the sanction is necessary.
Cognizance with challenge.
This page 849, the judgment, page 849, on the third paragraph, paragraph is not mentioned, on a conjoint reading of both the subsection 1 and 2 of section 45 of the UAP Act, it is clear.
Therefrom, that the state government is required to appoint an officer to act as a authority
for conducting
an independent review of the evidence gathered.
Yes.
In the course of investigation, and such officer appointed to carry out the independent review and shall make a recommendation.
Recommendation with the time to make and prescribe to the appropriate government. Not the the state of Orissa has not any officer to carry out the independent review, and further there has been no prescription of any time limit for making the necessary recommendation.
Yes, Mr. Maharaj.
ମୋ ପାଖେ ତ କିଛି ଡକ୍ୟୁମେଣ୍ଟ ନାହିଁ ଯାହା ମୋ ପାଖେ କିଛି ନାହିଁ.
The proceeding has to be stayed. He is covered by the judgment, direct judgment, and the Supreme Court judgment. What? Insofar as 124A is concerned, Supreme Court says that you have to keep in abeyance.
Yes.
No problem. Insofar as other offences under UAP is concerned, chapter 4 offence and chapter 5 offence, sanction is required as per this judgment. Bound by this judgment, what?
ମତେ କପି ଦିଅନ୍ତୁ ସବୁ ମୁଁ
No, issue notice to the
କପି କିଛି ଦେଇନାହାନ୍ତି ମତେ.
the petitioner has challenged the
ଯାହା ସବୁ
order dated
ମତେ ସବୁ ଦେବେ ସେଇଟାକୁ.
Reference ଦେବି ନା judgment
order dated 2/8/2023
ସବୁ କେସ୍ ସବୁ ଯାହା ରିପୋର୍ଟେଡ୍
2/8/2023
ନଉନାହାନ୍ତି ଶୁଭ
whereby
ସବ୍ୟସାଚୀ
his application under section 2
ମାନେ କମନ ସବୁଥିରେ ରିପୋର୍ଟ
227 application under section 227 sorry, 227 CRPC seeking a discharge has been turned down. Earlier he approached this court by filing CRLMC 1236 of 2016 wherein by the order dated 21/10/2022 the coordinate bench of this court had given him the liberty to raise all the issues before the trial court. Pursuant thereof, he moved the application under section 227 of CRPC, which is now turned down by the trial court by the impugn order. Mr. Jena, appearing for the petitioner, submitted that the trial court has not considered two vital points involved in this case, namely the invocation of section 124 capital A of IPC and prior sanction required for prosecuting, for taking cognizance for offences under section 16, 17, 18, 20, 23, oblique 20, 38 of UAP Act, UAP Act. UAP Act 1967. 1967. Good, sir. Mrs. Jana, relying upon section 45 of UAP Act 1967, submits that the prior sanction is required to take cognizance of offence under UAP Act. In the absence of the sanction, the cognizance order is vitiated. Therefore, the entire proceeding falls flat. He relies upon a judgment of this court passed in 2003. Relying upon the para, which para you are relying upon?
ସେଟା ସେ ପାରା କରିନାହାନ୍ତି ଖାଲି ପାରା କରିଛନ୍ତି ନମ୍ବର କରୁନାହାନ୍ତି ସେଟା
Relying upon the para 6, yeah, conjoint reading. So para 6 करो and last para, ठीक है ये 10. He contends that the cognizance order is bad in law. Hence the entire proceeding is vitiated. Full sir. Issue notice to
Here, my lord, the cognizance has already completed.
Discharge.
Charge has already been framed.
That's right, but the cognizance order goes, everything goes.
Charge has already been framed.
Maybe it vitiates. In order of cognizance itself is vitiated under the act. Issue notice, Mr. Maharaj accept notice, written within 2 weeks. In the meantime, the proceeding before the court so and so is stayed. He directly covered. Yes. Next.
Item 23. Item 23, let's say pray for 2 weeks after.
Yes.
27.
27.
May I please, my lord? My lord, here is this case for release of the vehicle in pre-trial stage, but that was refused by the trial courts, stating ground that is page 19, my lord.
Yes. What is the reasoning?
Reason, my lord, page 19.
Yes. Come on, read.
Hence, on perusal of the miscase filed by the petitioner, in the view of guidelines of Honorable High Court of Orissa, reported in WPC number 32580 of 2021 by a division bench and the CRL REV 404 of 2020.
Single headed by Justice Pujari.
Yes.
That the only prosecution investigation agency can only file an application for releasing of the seized vehicle. On the perusal of the decision of the report, it is seen that nowhere it is mentioned that the petitioner has filed this case before release of seized vehicle in respect of NDPC. Yes.
What do you only the ground taken in the page 19, my lord, that the prosecution public investigation agency can file an application for releasing of the seized vehicle, my lord.
What is your case?
My case is also release of the vehicle, which is also implicated in the NDPS case, my lord. So for the observation is concerned, my lord, that I also annexed that order, my lord, also. That is page 30.
In your case, what had happened?
My lord, my case is, that was rejected by the trial court.
Why?
This is the ground, my lord.
But application is not moved by prosecution.
Yes, my lord.
How to get out of it?
My lord?
How will you get out of it?
Yes, my lord. My lord, the section 52A is very specific, my lord. for release of the vehicle.
You want to review that guideline?
No. Guideline also not said that the investigation agency or prosecution has filed to my lord.
Where is the guideline?
My lord, I have also annexed, my lord.
So where is that?
That is continuing from page 42, my lord.
42.
Yes, my lord.
Yes.
May I read the whole judgment, my lord?
No, relevant part.
Relevant part, my lord.
Hmm.
This is the common judgment and how to dispose the seized drugs and the substance, the conveyance, my lord. This is the judgment, but nowhere in the judgment that prosecution agency or investigation agency has to file the release of the vehicle, my lord. That is not in the SOP. This is the SOP, my lord. This is the division bench order and this is the SOP, my lord.
Mr. Arora, have you seen it? Judgment. What do you say? What he says that the only ground is since the application is not moved by the prosecution, so therefore I'll not entertain.
Or investigation agency.
Where is that guideline? We see the judgment.
Just I am going, my lord. What happened, my lord? Improvement order. In impeachment order, seta semane gotte jinsa rely korchundi that judgment passed by Honorable Justice S. Pujari that prosecution agency will file for release of the vehicle. I am not the competent, my lord. I am not the competent. But after the amendment, 52 has inserted, my lord.
When the amendment?
Amendment in 2014, my lord.
This judgment is thereafter.
My lord. 52A is inserted after amendment of 2014, my lord. After inserted the 52A, a gazette notification has been already formulated by the central government. That is I also annexed. In that gazette notification, the central government fixed a manner, how in a manner the seized contraband article or conveyance will be disposed, my lord. That is there, my lord. I have annexed it also. Relying that the notification, three high courts, my lord. That is Patna High Court, Honorable Patna High Court, and Delhi High Court, and MP High Court, releasing the vehicle, my lord. But only the word in the judgment of single bench judgment that liberty to the prosecution or investigation agency to seek disposal of the conveyance, question under section 52A. This is the only
there is a difference between disposal and release.
My lord.
You are not asking for disposal. You
No,
are
I am
asking for release.
Yes, my lord. I am
So
released.
that is the difference.
Yes.
It just says that while disposing of finally,
Yes, my lord.
the prosecution has to, because it is under the prosecution.
My lord.
But you are asking for Jimanama.
Yes, my lord.
release.
Yes, my
So
lord.
that is a different thing. This is a different thing. The
My
trial
lord.
court wrong here. Trial court is wrong there. Yes.
See,
Mr. Ragada, just see.
Yes. Can taken up, my lord.
See, what is the difference
Well,
is,
I'll-
trial court says that it should have been moved by the prosecution only,
Or investigation.
but the judgment of the single judge says that for the purpose of disposal, prosecution will do. He is not asking for disposal, he is saying for release.
I'll be.
That is the distinction.
Yes, my lord.
And in the light of 52A, 52A says, how will you dispose of finally?
That is.
But suppose it is not released, it is there with you, then it is your responsibility, how will you dispose
Yes.
of? In that case, then
And
prosecution will
the
do.
impeachment order is very specific that the
No,
single
okay,
judge
I am
confusion hochi
I am
boli ki.
issuing notice of what?
Yes, my lord. Nai tapre a change chada no kadel according to giving liberty prosecution investigation
No, no,
that
no.
may be not deleted, my lord.
No, it is only for the purpose of disposal.
Yes, my lord.
If you want to dispose of a seized article,
My
you have
lord.
to seek permission. Who will seek permission? Prosecution will
Yes,
seek
my lord.
permission.
That observation may be
But
help to
for
me, my lord.
457 is something different. It is
Yes, my
released in Jimenama.
Yes, my lord. That
The trial
observation.
court is wrongly.
Yes, my lord. Seta to sabbo. So hundreds of petitions are rejected in the same.
No, that's wrong. Absolutely.
ଆଉ ତାପରେ ସେଠି entertain ବି କରୁନାହାନ୍ତି.
No, kole bolo na, you will come here. Why are you making APIL now?
Na IPS division bench judgment is very
Shall I
clear.
dispose it of saying that it is maintainable, let it be decided?
Another date, my lord.
I'm-
We'll transfer.
ସେ ଗୋଟେ ଜିନିଷ ତ ଖାଲି observation ଟା
No, what I'm saying is, the trial court is wrong to say that it is not maintainable. It is indeed maintainable. Let him decide on merits.
12th ରେ ଆସୁ ମୁଁ ରେକର୍ଡ କରିବ
आगे
ठीक.
obliged, my lord.
12th ମାନ
12th. You should notice 12th.
28
Shall I write it? Write something.
नहीं से observation टा खाली
Same for that.
what lordship observed today, my lord, that
You have a case then.
my lord.
That's the distinction. You remember
Aage,
it and tell that. You are not arguing here, there and all. The small point you are not pointing out.
Yes, my lord.
There is a difference between release
disposal and yes.
Insofar as the disposal is concerned, the SOP is fixed by the single judge saying that it should be moved by the prosecution. But I am not asking for disposal. I am asking
Jimanama.
Jimanama release and under 457.
Yes, my lord.
So that is not operative again. That is the whole case.
Obliged. Bar पर
Yes.
May I please? Your lordships. It's a petition for recall under section 311, which is before your lordships. By a non-resident cryptic order, the learned court below has declined to entertain my petition, which has been rejected. The prosecution case is like this, my lords. The 164 statement was been examined of the victim girl, and the 161 statement, it doesn't corroborate properly, and the FIR is also given. So far as the victim girl is
not filed, notice is not filed.
Not filed.
फाइल है ये हाँ
ये तो record कैसे record
Then sorted. Let us see.
Oh.
Idea is to bring her and settle.
yes.
Let us see. Huh?
20
Obliged.
finish.